Yes. Well, one of the things about moving to 50-50, which is what the law is starting to do, even though we hate it and we're still fighting it on the family law.
Oh, that person.
Can everybody mute their lines, please?
I'm on a webinar from 10 to 1, so anyway, I can work with it. Anyway, what activity?
Good morning. This is Anita Casey from the State Bar Center in Charleston, and I want to welcome everybody to our our July webinar presentation. Today we have two particular areas that we are going to cover. The first two presentations will be on family law. We have Judge Patricia Keller, who is going to address case law issues, recent case law on family law. Then we have David McMahon, who is going to address recent legislation regarding family law. Our second topic is going to be evictions. That's extraordinarily important now because of the moratorium on evictions, which ends next week on July 31. And we will have Susana Duarte and Katie Marcum of Legal Aid, who will be presenting later on that. The seminar/webinar today is worth 3 hours of general credit. After we finish this afternoon, and it probably will be this afternoon, but I'm not going to commit Mike to it, our IT director here will send a email to everyone. It will provide for 3 hours of CLE credit. If you were able to participate for all 3 hours, please accept that. If you had to step away for whatever the reason was, and you were down to 2 hours or 2.5, please make the correction on your time before you accept it. It is absolutely essential that you accept this email, otherwise it will not go on your transcript. If you do not receive the email by Friday, then please check your trash. You will probably get it today. Do not call us until you have checked your trash. Please do not call us until Friday. If you don't have it by Friday and it is not in your trash, then you can call the State Bar office and someone will look at it and find out why you did not receive it. Today, the speakers are going to have me take questions throughout the course of their presentations. So let me give you my email address so that you can send your questions to me. And it is very important. I have never done family law. I'm going to learn more today than I have ever learned. So I don't know what you're asking. So please look at your question and be sure it is in question format. I will read it verbatim to the presenter. The question, as I said, should be in question format, and it should be sent to CASEYA@wvbar.org. That is KCA@westvirginiabar.org. I'm not going to take any more time. The presenters have each been asked to give a very brief bit of information on why they are qualified to be the presenter. Their long CVs are with the materials you should have received yesterday. They went out yesterday morning. If you did not get those, you can email me and we will make sure that you get the materials. With that said, I'm going to turn the presentation over to Judge Patricia Keller.
Thank you, Anita. I'm Patricia Keller. I am one of the family court judges in Huntington, West Virginia. I have been a family court judge since the beginning of family court. So that makes me really old. In fact, just to give you some perspective, I was one of those lawyers that had diploma privilege when I graduated from law school and didn't have to take the bar exam. Okay, I'm not the only one. Very good. Well, I have some materials that I've included for the presentation today. The first thing I just want to tell you what they are so you'll know. This is a little packet of statistics for people that like numbers. It's got some information from the Supreme Court. We have to include all types of statistics for their reporting purposes, and that gives you some information. There is a handout on the briefs of family law cases from the last 2 years. When I did this, I did it for a 2-year period because we didn't really get out and have a lot of training during COVID. And so the actual materials cover decisions from the fall term of 2019 through the spring term of 2021. We won't be talking about all of those cases today, but I did include all those in the material, so you'll have those available. And there's also a PowerPoint presentation that we're going to go over. So let's get started now that we've gone through the background for us. Like I said, the first part deals with some statistics. I just like the number stuff. And what I found kind of interesting was that we've had a fairly substantial decrease in family court cases that have been filed. Not really sure why. I'm sure in more recent times, COVID has been part of that, but some of it may be the population decline in West Virginia. I doubt that people are getting along better than they usually did. But anyway, just for your information, we do have a fairly significant decline in family court cases or new cases that are being filed. We had about a little over 20,000 of those new cases in 2019. That's the last full year recorded, or 2020 rather. And we had 6,000 modifications for contempt proceedings, which would have been cases that were reopened. And then we had 806 guardianship matters in family court. And of those, about 18% got removed onto circuit court for an overlap. Family court judges also performed some weddings along the way, but not a whole lot, about 470 of those. The next slide talks about just a little brief summary of how appeals fell within the circuit court, from family court case to circuit court judge. There were 425 filed, and the statistics we keep for that is for the fiscal year. So that means it is from July 1 of 2019, or I guess, yeah, through June of 2020. And 69 were refused, 40 were remanded back to family court. Most of them took about 62 days to resolve. But I was surprised to see what the subjects were. Most frequent were domestic violence cases, and child support I'm not surprised by, custodial allocation and decision making, that those weren't really a surprise. So during this term of court, or the last 2 terms of court, there were actually 21 signed opinions related to family law and 40 memorandum decisions. Like I said, we're not going to cover all of those. I've divided them up into some categories that I want to do by subject areas. So the first group of cases I want to talk about are those that deal with judicial authority. Those are Aaron versus Montgomery, State Ex Rel St. Clair versus Howard, Rector versus Ross, and Darnell versus Elizabeth. You'll notice in the PowerPoint, there's a little asterisk beside Darnell versus Elizabeth. That doesn't mean it's because it's the most important case. I just did that for my designation to make reference to the fact that that was only a memorandum decision as opposed to a signed order. All right, the first case, Aaron W. versus Montgomery. That was a case out of Kanawha County. The Montgomery was Rob Montgomery, the family court judge here in Kanawha County, or one of them. And the issue before that was whether or not the family court judge has the authority to disqualify an attorney appearing before them. What happened in that particular case, an attorney was representing the husband and the wife in a personal injury action. Husband had an auto accident, wife's claim was for loss of consortium. This same attorney files for a divorce on behalf of husband. Wife is pro se. Prior to the conclusion of their divorce hearing, wife decides, in consultation with her attorney in the personal injury action, to dismiss her claim for loss of consortium. The reason for that was the attorney advised her it didn't have much chance of success, and so it was dismissed. Then the final divorce happens. As a part of the equitable distribution portion of the hearing, the family court judge did not address this settlement. It was a confidential settlement. The only thing put on the record, the wife put on the record that she waived her interest in it, but she was never told what the value was. It was confidential. Later, she has an attorney who files a motion to reopen that matter and have the attorney disqualified because of a conflict of interest. And the attorney objected to that, saying that the family court judge does not have any authority to regulate the ability to practice law in their court. And the Supreme Court said that yes, the family court judge could disqualify that attorney. And there's a new syllabus point related to that. And it's in the materials, it's also in the handout. But basically just says the family court judge may disqualify a lawyer from a case because the representation presents a conflict of interest where it's clear to all people involved that it would affect the fair administration of justice. The next decision that came about in the judicial authority area is the State ex rel St. Clair versus Howard case. Now, this case is a little bit different in that it's actually a circuit court judge heard a divorce case or had the divorce case. And you may or may not be aware that circuit court judges can hear divorce cases if there are no children, the parties have a settlement agreement. It's uncontested. I mean, they can do that. They get to do the easy fun ones, right? So anyway, in this particular case, the St. Clair versus Howard case, and Howard is our circuit judge in Cabell County. The attorney, Mr. St. Clair, goes to the circuit court judge to file the case. I remember this at the time because our circuit clerk's office wasn't sure what to do with it because they weren't aware that circuit judges could hear these divorce cases, and they didn't want to assign it to a circuit judge. But I said, yes, the statute says you can. So they did that. And Mr. St. Clair prepared a complaint. He prepared the answer for his wife to sign, agreeing to the irreconcilable differences, waiving notice of the hearing, waiving service of the complaint. And he also filed with it 2 very skeletal financial statements. And both of those statements really had nothing much more in those other than the dates of birth, their addresses, and just said that parties had reached a settlement on their property matters. And that was basically it. And unbeknownst to the wife, the husband went ahead and approached the circuit judge and got him to sign off on the divorce order. Circuit judge never had a hearing on it. He had an agreed order that was prepared by the attorney, husband, and signed by the wife. The wife supposedly thought there was a chance of reconciliation. So, she had been texting and emailing with her husband about that, talking with him about that. And so she wasn't really aware for a while that she was actually divorced. Later, she found out she was divorced. And about a year after the divorce was granted, she hires an attorney who brings this matter back to court on a Rule 60B motion. And the reason they do that is because husband has some substantial assets. During their 6 years of marriage, he made about $5 million, which he claimed was separate property. But it got reopened so that they could look into that issue. The question is, does the circuit court judge lose jurisdiction once this becomes a contested case? And the Supreme Court said, no, they don't lose jurisdiction. They can still do it. What happened in this case, the circuit judge did not set aside the divorce. And he did not do that because husband had remarried. And that would create some additional problems for the new wife and the bigamy and et cetera. So what he did is he upheld the divorce, but he set aside the property settlement agreement. Because he said that it really wasn't an agreement because the wife thought there was a chance of reconciliation. And so that implicitly revoked the agreement. And so he remanded it to to the family court, asking the family court judge to have a contested hearing on equitable distribution. So the second issue in that particular case is whether or not a family court judge can do that. And or whether the circuit judge can have the family court judge take it back. And the Supreme Court said, yes, they can do that. So a very convoluted case there. Speaking of convoluted, the next one is Rector versus Ross, and that was a contempt case. There were 2 issues in that. One is contempt that a circuit judge assessed a fine against an attorney for misconduct. And was that a contempt sanction that he was entitled to have certain rights, such as a jury trial, or was the court just acting on their own inherent authority? And a review of the record said basically that yes, it was a contempt action because it was issued as a result of in order to show cause why you shouldn't be held in contempt, a finding of misconduct, etc. So it was a specific fine of $5,000 due at a certain time. And so they said that was a contempt sanction. And so he was entitled for due process to have a jury trial. So that part got set aside. The other issue in that case, which kind of got unresolved from us from a family court perspective, was while this appeal was going on in the Supreme Court, there had been a contempt action filed in family court, totally unrelated. And just to give you some real background on that story, the stuff that doesn't show up in the appeal, this case involved 3 actual types of legal proceedings. It came about because a wife showed up at a bar parking lot, saw her husband coming out with a girlfriend, got a gun out of his truck, shot him, but didn't kill him. So there was a criminal case, and as a result of the criminal case, wife gets convicted and is incarcerated, and there's restitution to the husband. So she owes him money for that. There was a personal injury action, she owed him money for that because of the shooting. Then there was the divorce case and inequitable distribution. He owed her money. So there were 3 cases involving judgments. And the family court had a contempt hearing because the property belonging to the wife, her separate property, wasn't returned to her. And the husband wanted that stayed pending his appeal. We were hoping we would have some type of a ruling from the Supreme Court saying, since that's not an issue that was on appeal, we could go ahead and proceed. But there was a stay order by the circuit court to stay all contempt proceedings pending the appeal. He filed a writ of prohibition against the family court judge because after they settled their case in the Supreme Court and he dismissed his appeal, the family court judge proceeded on the contempt action. He said, hey, there was a stay order, you don't proceed on that. And the ruling was, well, once the stay was lifted, the appeal was over, then we could proceed. But we would have liked to have had a ruling that would have said, if this was not an issue that was part of the appeal, that contempt could go forward. Because, you know, and appeals take a long time. The last one under the authority is the Darnell and Elizabeth case, the one that was a memorandum decision. In that case, and it's something that we see a lot, we have pro se litigants, we have wife files for divorce with a fault ground and also irreconcilable differences. Husband files an answer, denies irreconcilable differences. They both file financial statements, but they're not great financial statements. Family court judge continues the hearing for 2 reasons. One, because wife now needs a witness for her fault ground and she didn't have it at the hearing. And 2, because the financial statements weren't adequate enough to divide up their assets and debts. Husband objected and appealed saying, hey, wait a second, this should have been dismissed. And the ultimate ruling from the Supreme Court was that the family court judge could sua sponte continue a case. The rules allow that, but you have to have good cause and include that in your order, and it has to be only continued for about 90 days. And that happened in this case. The family court judge's position was, hey guys, you're just going to be back again. You're wasting a lot of time and resources. Let's just do it. Next are some paternity cases. The first one, Corey versus Travis. And in this particular case, they asked the question of whether or not we could disregard a DNA test that says you are the dad. Family court judge did that, kind of on a twist on Michael KT cases. What happened is this couple never married, had 3 children. They were together for a really long time, separated. While they're separated, wife gets pregnant by somebody else, does a BCSE action to get child paternity established and child support. Then she and boyfriend get back together. They have another child of their own. Okay, so they have 4 kids altogether. And then there's this one kind of in the middle that's not the actual biological boyfriend child. They separate finally for good. At that point, BCSE's paternity action is still going forward against the alleged father of child number 4. And he does a DNA test, and yes, he is the biological father. But the boyfriend files an action saying, hey, I have raised this kid. I'm the psychological father. I want to be found to be the psychological father. Family court judge felt that, you know, he's the one that has all this relationship with the child, so they made him the father. and disregarded the DNA test. And the Supreme Court said, no, you can't do that. The statute's very clear. You got to take that up. Now, that doesn't mean you can't consider whether he may be a psychological father for having some visitation, but you can't just say you're not the dad. And again, there's a new syllabus point on that. The next case that deals with paternity is Michael versus Brandy. And in that particular case, this couple is married, and the wife gets pregnant by another man during the separation. And that other man files paternity action after the mother and her husband get back together. And they object to allowing the putative father to pursue paternity. So that's what this case is about. Should this putative father be able to intrude upon this marriage and pursue a paternity action? The facts in that case were this married couple separated a lot. And when they would separate, the woman would go down to the southern state, I forget which one, Alabama, Arkansas, one of those 8 kind of states down there. And she hooked up with this guy, got pregnant by him. She would go down periodically with the child. He would act as daddy for this child while they were down there. He would help provide support for the child, do things with the child. She would come back to West Virginia, keep him up to date on how the child was doing. Ultimately, she gets pregnant a second time. And at that point, she stops it all and says, I'm not going to let you be involved anymore with this child. And he files a paternity action to say, I am the dad of this child, and I may be of this other baby coming. And so the question is, we have a Stone case that talks about when you can intrude, when you have this protected constitutional right. And it didn't quite exist in this particular case because he had never really formed a real substantial parent-child relationship, because he was barred by doing it from this woman. He tried and he grasped a little bit of a one, but then she stopped it and wouldn't allow it to continue. And so in a very close decision, 3-2, they decided that, we're going to extend the Stone case a little bit further because he did grasp at that opportunity. And so we're going to let him pursue a paternity test. Turned out that he was the father of the child, but not the second child. And of course, the dissent related to the fact that, that's a legislative function. They should be the one extending this step. You find it unconstitutional, let them fix it. The last paternity case is really a maternity case. It's SU versus CJ, and that was a memorandum decision. And these people had their children through very non-traditional means. And at the time of their separation, they were not, I don't think that they were married. I think it was custodial allocation. But at the time of their separation, Dad tried to make a claim. Mom was just a gestational surrogate. And so the kids are mine. I'm the only one that has a connection there. And the court didn't buy that. But the facts were very interesting in that when they, before they were married, or before they got together as a couple, I should say, it does not identify as a man or a woman at the time of birth. And he had surgery to correct some anomalies. And as part of that surgery, he had his eggs harvested and stored. The girlfriend never knew about any of that. He legally had his name changed before they got together or anything like that. Was a registered nurse. The first child that they had together, they had by in vitro fertilization he was a nurse and he did that at home. She thought it was his sperm. It wasn't his sperm. He got it from somewhere else, but we never found out where. Then the next time they had children, they went to a clinic in New York, and she was, they fertilized the eggs and implanted the egg. She thought they were donor eggs with his sperm. It turns out they were his eggs and donor sperm. And they had a child, and then they did it again. This time they had twins. So there were 3 children born with his eggs and donor sperm, and 1 child that was born with her egg and donor sperm. So it's a very odd scenario. But anyway, what the court said, look, if you want to say somebody's not the mother, you've got to prove they're not the mother, that this really is a surrogacy arrangement. And he had a contract, but it was not notarized. He couldn't find the notarized copy. And of course, she denied that. So they found that she was the mother because she gave birth to them. There are two cases that deal with custodial allocation and decision-making, Benton versus Cassidy and Heather versus Richard, that I've included in the materials. The first one, the Benton case, talks about overcoming the shared decision-making provision. And these folks had a 50-50 split in their parenting arrangement. And what happened was there were three issues they just couldn't agree on. One of those issues that they couldn't agree on was whether or not the child would be homeschooled. Another one was whether or not the child would be immunized. And the last one was the child's allergies. And the allergies really became the issue because mother kept insisting over time that more and more things this child was allergic to. But when the child was with dad or paternal grandmother was showing no allergies to these things, was tested showing no allergies to these things. But mother in her head was convinced that he was allergic and was more and more allergic to things. And so the family court judge in this case found that there would be shared decision-making because they had 50-50 split. And dad appealed that portion of the order. And the Supreme Court said, no, there are times that you cannot have shared decision-making. One of those times is if there's a history of domestic abuse. And the other is if there's a showing that joint allocation just is not in the child's best interest. And they found that their decision-making ability was just not possible. They could not meet on those three issues, so it couldn't be done jointly. The other case that I listed under the custodial allocation section, Heather versus Richard, is a case out of Kanawha County that had two issues with it. One issue dealt with when you would have a supervised visitation. In that particular case, the husband or the father was abusive and he left. Mother files for custodial allocation. At some point before they actually have a hearing, she asked him to come back and have counseling and work on those anger issues. He decides not to do that. So they go to court. Mom wants to bring up at the temporary hearing that we need to have some supervised visitation because of family court judge did not let her present that evidence. Husband got his 2 cents in to say, hey, after we separated, she invited me back into the house. And the family court judge took the position that don't come here and tell me he's a bad guy because you invited him to come back. So I'm not going to hear any evidence on it. When it came time for the final hearing, she gets a lawyer to represent her. And the lawyer says, Judge, don't forget, we need to talk about this. And husband or father interjects again, hey, don't forget, she let me move back in. I'm not a bad guy. And family court judge again said, I'm not going to let her bring that up because she let him move back in. Don't tell me now he's a bad guy. I found that kind of strange, but that's what happened in that case. The lawyer had even gotten the pediatrician available to testify because of the child's anxiety about what was going on with dad. Again, family court didn't want to hear it. And so the Supreme Court said in that case that whenever there's credible information or a request made by one of the parties for supervision because of domestic abuse, you have to have some type of inquiry, investigation, or allow evidence. So that's not okay. The other issue on this was the custodial parent was not employed outside the home. And so, the statute provides they would normally have the tax exemption credit. And the family court judge gave it to the father because he paid a lot of child support and said that maybe if it turned out it would help the mother out at some point if she got a job, she'd split it with them and they could each have one of the children. And that was also appealed because that's not what the statute says. Now, this is one of those new questions that's coming up for us. I noticed we've started to have some emails circulated around the family court judges, and that's like, what are we going to do with this new tax credit money that's coming? How do you count that? And so far, there's not been a good consensus of thoughts on how we're going to count that. Is it going to be added to your income for alimony purposes? Does it count in child support in some way? So, any thoughts on that, anybody? We'll see how it goes, huh? Okay, then the next category just deals with some child support cases. The first one, Amanda versus Hakeem. In that particular case, it gives us a new syllabus point. It talks about the Social Security disability payment when you have a disabled parent. They ran a formula in this particular case, and the father was disabled and got Social Security disability benefits, and the children got a benefit based on that. What happened was he ended up being the custodial parent, and the mother had a support obligation, and the family court judge looked at that and said, well, the benefit for the children is a little more than what the mom's obligation is, so I'm just going to zero that out. Even though the Social Security did not come through mom, it came through dad and his disability. And so the code says, hey, you have to credit it on dad's side because he's the one with the disabled parent, and give him the credit, not her. And they did a new syllabus point just so we don't forget that. The next case is Hassan versus Tamra. This is I kind of think of this as the family court judge was not happy with this guy case, you know, and it just wasn't going to work for him no matter what. But what happened is he had a long history of not paying his child support. Plus, when child support was first set, he was a guy that didn't have a legitimate, easy to calculate income job for the formula. He worked for his parents, but said he didn't get paid. He had all these credit cards he didn't have to reimburse. He had all these expenses paid for him. He quit a job or ownership of a car wash business where he had a whole lot of money coming in. Basically, he minimized to say, I'm not working, I don't have any income. And so much income was attributed by the family court judge based on all the income that he was having available to him as from his family. So they set a child support obligation, and that got appealed and that got upheld. So he comes back multiple times on contempt hearings because, of course, he falls behind. He gets put in jail. He pays off some. He gets behind again. He comes back to family court this time and says, change in circumstances, you know, I need my child support adjusted. You know, where's this going to go, right? Family court judge is still attributing all this income to him. Supreme Court said that's okay. But two of the children no longer live with mom. They live with dad. And mom has a job now that has a substantial increase in income from what she had when child support was first calculated. Family court judge just doesn't consider that. Just unclean hands. You bug me. I'm annoyed. Go away. Supreme Court said, look, you got to recalculate child support because these were changing circumstances. Two kids don't live there anymore, and mom has significant increase in income. So that was recalculated for that guy. John T. Angel T. I only put that memorandum decision in here because it makes me think of my brother. One of my brothers is a nuclear engineer, and he works in South Carolina. And the guy in this particular case worked at that nuclear plant. He got fired from his job. I think there was a domestic violence incident. Wife and kids end up in West Virginia. He ends up in Pennsylvania looking for other work. And at some point, the issue comes about modifying the child support here in West Virginia. And our statute requires that support be modified till the child graduates from high school, or if they're continuing past, 18, but making progress. You know the statute. And dad said, wait a second. In South Carolina, it cannot continue past 19. So the West Virginia statute that says it could go all the way up to 20 under these circumstances can't do that. And the Supreme Court basically said, yeah, you can, because we found this case in South Carolina that said child support incident to certain things. So we'll let it continue. Again, not a very beneficial case, other than it makes me smile thinking of my brother. The NRA AW case, this is another case where I think if it had been a respondent or a petitioner, I guess, that was better liked, maybe the outcome would have been different. This was a case out of Mineral County. This fella had a child and a stepchild, and he had his parental rights terminated for sexual abuse of the girls. Ultimately, the family court set a child support obligation for him as part of that process, even though his rights have been terminated, his responsibilities weren't. And that was being collected by BCSE. At some point, unknowns to him and BCSE, mom's new husband adopts the child. So he's still paying child support. It comes to several $1,000s. So he wants to have it reimbursed. He wants to do income withholding to reimburse himself for that. And mom said, wait a second, he has a lot of medical bills, plus he was supposed to have health insurance for the child. And he got credit in the formula for that. And he didn't do those things. So I need some credit there too. And the court said, you're right. There's nothing in the order that says if she doesn't timely notify you of medical bills or challenge these things to bar that. So we're going to deduct from any reimbursement she owes you all of these other things that you owe her. So that's that case. Frederick and Mary, not much to that case other than this guy's a trucker and he's not real cooperative about presenting his income information for calculating child support, even though he was warned several times by the family court judge. Ultimately, what he did was he provided 1 quarter earnings statement, and the family court judge did what would seem reasonable, multiplied it by 4 to get a yearly amount. And he objected that that's way too much money and it's wrong. And the family court judge was upheld saying, look, that's the best you gave us. That's reasonable. There are a couple of relocation cases in here. They don't like relocation cases. We'll see how they come up now. We'll talk with Dave and our new statute. But anyway, relocation cases. The first case in that one, let me see if I can find that one in my notes. The Stacy case. Again, litigants have a tendency to say things that really do impact judges. I'm not saying properly, okay? But it does, and this is not a good thing. Because in this case, she had filed relocation a couple times, or modifications rather, and didn't really go anywhere. And there was some issue about child support in that, and she got upset with husband. She made some comment about it's all out war now over child support. And so that's the background. And the family court judge was told in this upcoming proceeding, this is all about child support. This is what she said. And so that colored the idea of the family court judge, I'm sure. That and the fact that mom lost her job. She was a CT technician. So she lost her job, and that's why she needed to relocate, because she couldn't find a similar job in West Virginia, and she did not want to take a job that paid less, which seems reasonable. So she was looking in the South Carolina area, which is where Myrtle Beach, where everybody goes to move and or vacation in our neck of the woods, it seems like. And she said the reason that she lost her job was because she injected the wrong patient with dye. And there was a mistake and da, da, da. Well, it turns out at a subsequent hearing, it comes out that she really got fired because she was improperly accessing the medical records of her ex-husband's new wife and child. And so again, family court judge is like, I don't like you. And again, I'm not saying that this is the right thing to do, but unfortunately, I think it happens sometimes in these cases. So it turns out mom has a close bond with these kids, according to the guardian who investigates. The guardian wants to move to South Carolina, and family court denied the motion to relocate and also reduced child support. And that goes up on appeal. And basically the court said, look, you got to look at the factors, what's in the best interest of the child to move, and the children are very bonded to the mom. So that was that case. Nathan versus Ashley. I love this. This is one case where they finally said, circuit judge, stay in your own lane. We get a lot of family court judge, stay in your own lane, particularly in guardianship cases, when we do guardianship hearings, when we should have removed them on to circuit court. In this particular case, there was a relocation matter. Parties had equal custody. Mom relocated within state, and the parties worked out their own agreement to modify parenting very maturely and did like a 65 35 split, something like that. Worked out well. Mom files to relocate again, fairly close. I mean, we're talking from Raleigh County to Greenbrier County for a job at the Greenbrier Clinic that paid more money. She was in healthcare, and it all sounds really good and reasonable, etc. But the family court judge found that that was not in good faith. And so anyway, I'm sorry, I mixed that up. That's because of the child support issue, saying that it was all out war. And it goes on appeal to the circuit judge. The circuit judge says this really is in good faith. It's a legitimate reason. It needs to be approved. And he sent it back to family court to address the child support issue and relocation costs, things like that. And while that was going on, mom marries somebody that's a doctor who has a new job now in Virginia. So she files a new relocation to go to Virginia, which wouldn't affect the parenting plan that had just been approved by the circuit judge. Okay, but it's not the same parenting plan because a new relocation move. So she files a motion, says, circuit judge, would you take jurisdiction of this because it's all the same issue, judicial economy, da, da, da. Circuit judge said yes, grants that relocation. And the husband says, no, you have no jurisdiction to do so. And the Supreme Court said, that is correct. You have no original jurisdiction to do so. that case had to go back down in front of the circuit or the family court judge. There's one UCCJEA case that I threw in these materials. It's an abuse and neglect case. It's not even a family law case, but it's a good discussion of home state jurisdiction. This is a case where a pregnant woman who lives in Virginia, right across from the West Virginia line, goes to Bluefield to have her drug endangered baby. Baby's born, tries to leave the hospital with the baby, cut off the bracelet, etc. Gets caught, step in with an abuse and neglect action because of the drug endangerment. And the whole case talks about whether West Virginia should have had jurisdiction or whether Virginia should have had jurisdiction. What happened was West Virginia proceeded as though they did have jurisdiction in the abuse and neglect case, saying it was the home state for the child because the child was born there. After the child was released from the hospital, the abuse and neglect case placed it in foster care in West Virginia, so the child was always in West Virginia. Ultimately, mom's parental rights were terminated, and it was at the appeal from her termination of parental rights that she said, you never had jurisdiction to start with. And the Supreme Court said, unfortunately, you are correct. And so even though she didn't raise it earlier, and they wish she had, courts always need to be cognizant and aware of jurisdictional issues. And they talk about the 4 ways you have jurisdiction under the UCCJA for young children. It's a very instructive case dealing with the UCCJA. So if you have one of those kind of cases, I would suggest that. And again, there are 4 new syllabus points. Grandparent visitation case. We had 2 of those that I mentioned. The first one was the grandparent visitation of LM et al. This was a case out of Nicholas County, and anybody that ever tells you about this case will just tell you it is just horrible facts, traumatic case. Parties divorce, mom has custody of several children, dad has supervised visits, they go to the visitation exchange site, dad with his father, who is the supervisor, maternal grandfather takes the children to meet them at that site. He pulls out a gun, shoots and kills dad in front of the children, then turns the gun on himself and kills himself. Again, the children are there and witness that. Request by paternal grandparents for an ex parte order that the children can go to dad's memorial service. Family court judge denies that. Filing for grandparent visitation. Big hearing on that, very long involved hearing on that. Some problems with the record. I didn't record and offer to redo the hearing, which was unusual, and duly noted by the Supreme Court that that was a very generous offer. Parties chose not to do that. Very detailed order by the family court judge that set out a lot of findings, evaluated all the factors for grandparent visitation, and noted the most important one, the one we're supposed to give special weight to, is mother objected, but ultimately found that reunification visitation would be in the best interest of the children. Mom files for reconsideration, and instead of, I guess what she does at that point is bring the therapist for the children to testify to say they've now changed their mind that it probably wouldn't be in the best interest of the children. And the family court judge delays the phased in visitation in a therapeutic setting, and it was upheld by the Supreme Court. And there are 2 dissents in that case talking about, we've got to look at the best interests of the children and not feeling that was done properly. And the concurring opinion was basically an attack on the 2 dissents in that particular case. But it goes to show you just how hard some of these decisions that family court judges have to make in these cases. And it was a 3-2 decision. The other one, Megan versus Terry, came out of Cabell County. It was not my case, but it shows you like kind of the difference. This was a case where one of the things I've learned by doing these updates is the importance of making good findings. Okay. Now, what my takeaway is from doing this presentation is how important it is to actually have a hearing. In this case, the family court judge made findings, but he didn't have a hearing. He didn't take any sworn testimony. There were no stipulations. He just used the guardian's report. And a fit mother objected to grandparent visitation, but he granted it anyway. And so that got overturned. We said, look, you got to go through those 13 factors, and you got to give special weight to the mom. You got to give us a hearing to show a basis for the findings that you make, not just that it's in the best interest of the child. Guardianship cases, we're kind of running out of time, so I'm going to skip through those two pretty quickly. Basically, they just say stay in your same lane. Circuit judges and family court judges have concurrent jurisdiction in guardianship cases subject to the removal jurisdiction. So if there are allegations of abuse or neglect during the hearing or in the petition, we have to remove it to circuit court. There were the two cases I went by real quickly. The family court judges just didn't do that, and so those orders were vacated. That leaves me with a little conundrum. I was in the office yesterday and I saw an order from one of my circuit judges on a removal case I sent to circuit court because the petition is full of allegations of abuse and neglect. An order came back from the circuit judge saying, after it was investigated by DHHR, they did substantiate neglect or abandonment, so I'm returning it to you. And I don't know how to respond yet to him. I have to work on that because there are no backsies in the family court rules that say once it's been removed, you can take it back. So I got to figure out how to do that. The David versus Tammy case is just a case saying, hey, you got to have good notice in your hearings for things. Guardianship request to terminate by the mom, and she sent notice to the grandmother who has the kids, not to dad, who'd never been in the picture, never visited, but believe it or not, paid his child support. When the guardian ad litem tracked down, there was a dad and told him about the case. He shows up to visit with his daughter, who's like 13 at this point and never seen him before. And he shows up at the hearing because he wants to have visitation. And the family court judge denied him visitation because the guardian report said that in the past he'd had some abuse issues and he had a drinking problem, but she never allowed the dad to testify about any of those or refute those statements, and dad never even got the guardian report. So he didn't have it in advance either to be prepared. So basically not a fair hearing to dad, do it again. The Terrence and Christopher case just talks about the distinction between permanent and temporary guardianships. And the circuit court judge in this case was not going to revoke a guardianship. And the Supreme Court said, yeah, you needed to in that case because it's a different standard of proof in that. This was only a temporary guardianship. It wasn't permanent. You had a fit parent. There were certain circumstances that required the children be temporarily with the grandparents, but now those circumstances were over. And so, needs to go back to dad. So if you want to terminate a guardianship, that's a good case to look at. A couple of adoption cases in there. The first adoption case happened because in that case, an aunt was going to adopt the children. Their parental rights had been terminated because parents had drug issues. So she and her husband were raising the kids as foster children. We're going to adopt them. About that time, it turns out her husband has a drug issue she didn't know about. She files for divorce, kicks him out. They allow her to adopt separately. When the order is granted for the adoption, the circuit judge puts in the order that she's not allowed to allow her ex-husband around the children. But grants the adoption. She's a fit, proper person to do that. A year later, he's seen the light. He's recovered. He's done all good things. She wants to allow him to have contact with the children, so she files something to take that provision out of the adoption order. And the circuit judge said no. And on appeal, they said, look, you're finding her a fit parent, able to make her own decisions. And so you can't put that in an order. So they kicked that out. The next one, Murrell versus Clarence, that was a case where a child was placed with this couple because they thought there was a relationship there by an in-law. Turns out there was no biological relationship there. Another couple ended up then taking him that were relatives and raising him as a foster child. And they filed for guardianship. And as part of the guardianship, the original couple gets visits. And that works out fine. The couple that have him decide to adopt him. Everybody goes to the adoption hearing, both sets of people. It's all good. They adopt him. They continue to have visits another year or so. Things break bad. Adoptive parents say, no, I don't want you to visit anymore. And so the visiting folks file a petition to get this visitation because they had it under the guardianship. And the court said, no, adoptions terminate those old relationships. It's a whole new ball game. If the order in the adoption did not provide for visitation for you, you have no standing to have visitation now. Spousal support case. These are the Campbell case I put in there because this guy, toward the end of their marriage, he got sent overseas to Saudi Arabia for Dow Chemical, and he was making huge money because he was working overseas. And when they got divorced, they based his alimony obligation based on this very inflated income that he was earning. Now, everybody knew the contract was only for a certain period of time. When the contract was up, he couldn't get on over there doing anything else at that kind of income. So he went ahead and retired because he was of a retirement age. And at that point, all of a sudden, his inflated alimony was more than his retirement income. So he files to modify. And the court said that is appropriate because a payor spouse has to have the ability to pay it. And it wasn't like he intentionally diminished his income in some way. I mean, that job worked itself out. It wasn't an option for him anymore. It was just a special circumstance. On the Heather and Shane case, that was a case where the husband was an orthodontist and made buku money. I mean, huge, huge money. Wife helped him in the business and they had some children. At the time of the divorce, he wanted the divorce. At the time of the divorce, she asked for spousal support of a temporary nature, like maybe 5 years at a very reasonable amount, and then child support. Family court gave her 3 times as much spousal support that she asked for and made it permanent. So that gets appealed. And the circuit judge says that's pretty excessive. And it turns out, I think the child support she gets is enough to take care of her needs too. So child support's the only award given. Spousal support goes from excessive to 0. On appeal, the court says, you know, that's not really the purpose of child support, to support the spouse, but it does need to be reasonable under the circumstances. And Justice Workman made another pitch for the alimony formula. Curtis versus Laura, the really nice thing I liked about that decision, even though it's just a memorandum one, husband wanted all the good stuff in the marriage, all the good assets, the accrued leave, the retirement investment accounts, the house, and some of that came with some debt. So he took all the good stuff and all the debt that goes with it. And all of a sudden he's like, now I can't afford to pay alimony because my expenses are so high. But it was very much an alimony case. And the court said, you can't minimize your income by taking on all this debt in the marriage for that purpose. Not really too much in equitable distribution. That Raymond versus Cami case is the case that deals with the statute that replaced when they got rid of dower. And just how do you consider when somebody fails to give notice to their spouse that they encumber separate property and then divorce within 5 years? It's a very obscure case if you ever have that issue. The Kovac case was just one of those that I liked because the Supreme Court said, family court, you're okay not enforcing side deals. There was an equitable distribution award that husband was to pay wife a certain amount each month, and there was a sum certain total at the end. He didn't do it. She does a contempt action. Family court judge gets told, hey, look, I paid these third-party things for her, and we agreed to that, so I need credit for all of that. And she said, we didn't agree to that. And the family court judge said, hey, I'm only enforcing my order. I'm not enforcing side deals that you all worked out. So don't do side deals. In the Richardson case, it's trying to decide, is it a marital property or not all marital? Husband has a separate property, wants to get married. Wife's reluctant to leave her own home. To entice her to marry him, he deeds the house to her and him jointly. So she now is half owner in the house. At some point during their marriage, he gets in a little trouble with his garage and there's a lot of money to the IRS. He also gets in a little trouble by having an affair with somebody who's doing business there at the garage. And wife catches him. He ends up deeding his half of the house to her. So she now has the whole interest in the house and they're divorcing. And she says, hey, he gifted me his half. I don't owe him anything here. And he said, I didn't do that. That was the thing to avoid tax responsibility with the IRS and my liens there. And the court said, you know, it really was not a gift to her. That even if he was intending that to be a gift, there's a little duress here because of the being caught having the affair, and she's going to file for divorce. They found he was just trying to cheat the IRS. And the Roberts case, another case where a father gives a son real estate. They do consideration in the deed for $105,000. And at the time of the divorce, the husband tries to say, look, that really was a gift and he didn't give me any, or I didn't pay him for it. It's my separate property. And the court ultimately decided, look, there's a consideration that says you gave him $105,000. And he knows what that means because there was another piece of property that he deeded to you and it said no consideration. So we've seen a distinction there. We're going to consider that marital. Two quick domestic violence cases. I just want to point out the JC versus JM. That was just a typical hot mess domestic situation. And niece shows up at the farm of her aunt and uncle, checking on some property that's involved in a trust estate, see if it's been sold or still there. Uncle goes batshit crazy. Law enforcement gets called. Uncle gets arrested as all of this. And she, the niece, files against aunt for protective order. And she never says she was afraid of the aunt. The issue in that case, she said, I was afraid that she might hit some other family members with her car. She was in her car and mad. And I just wanted her to leave me alone. So the Supreme Court said, reversing that and instructions to purge that order from the records because, you know, you were never afraid of her. So that's an important part of getting a protective order. And then we have the no means no case. Girlfriend says, I was sexually abused by my boyfriend, sexually assaulted. Family court says, yeah, you told him no. You told him to please stop multiple times, but they still denied a protective order. There's something in the decision about a lot of receipts for Victoria's Secrets that seem to like cloud the waters in some fashion, but I'm not sure why. The Supreme Court said that was an abuse of discretion for the family court. No means no in this state, in case you didn't know. We now have a decision on that. On just appellate procedure, the Ethan versus Tracy case says that the appeal got filed late of the family court decision because he got an extension. That part was all good. On the day of the extension expiring, he drops his appeal in the mail. He doesn't drop it in the clerk's office. So by the time it gets to the clerk's office, the time frame's up. There's no mail extension under the family court rules for appeals. It's considered appeal when it's filed in the clerk's office. Magera case, in that particular case, family court judge was told to provide a DVD to the circuit court for review on the appeal, given a time to have that in. Circuit judge waited just a little bit to get that in. And as a result, to make the request, family court judge took their 10 days or whatever to produce it. It gets to the circuit judge a couple days late. Circuit judge dismisses the appeal on reconsideration, still denies the appeal for being late. And the Supreme Court says, you know, that's a bit extreme. The Kevin and Beth case and the Vladimir Miroff case, I just put those in there because both those cases have the same quote in it that I really like. Judges are not like pigs hunting for truffles buried in briefs. And in both of those cases, they basically said, we're not even going to address your appeal because you're not pointing out anything in the record. You're not making any arguments for us to consider. You know, you gotta do a better job presenting your brief on both of those. And the last one, the wife just appeals an equitable distribution award, and she fails to include a copy of the DVD or a transcript of the family court hearing. So there's no record for the court to review as a part of that. And they said, hey, just an inadequate record to review, so we're denying you. So those are the cases that I had, and sorry, I kind of probably ran a little bit too long.
Judge, we have no questions pending right now.
Good.
So we are not going to take a break. We are going to take about 30 seconds to adjust the height of the stand here, and we are going to have David McMahon as soon as we get his podium.
Hi, Dave, you're
Next. David, do you have a PowerPoint?
I do not.
Do not, okay.
You just have me on there.
You
When
will
I
be on there.
first went to legal aid, I was one of the first people with a laptop. Unfortunately, it did not have enough memory for the PowerPoint program to get put on it, and I've never got caught up. So I don't do PowerPoints.
Mike, we have a couple of videos that need to be knocked off. David, if you want to go ahead and get started, our IT director will take care of fixing the screen, and we won't take any more of your time away from you.
Okay. I don't have a PowerPoint. There are two documents that got circulated that I'm going to refer to. The first looks like this. It's a revised summary of the changes to the custody code. I'm going to be talking about changes to the child custody code by the most recent legislature. Probably more important for today, I also sent out a copy. Does this show up? Yeah. Of a version of the bill that shows changes from current law with underline and strike through. So that will be most useful to you. There's also on the legislative website what's called the enrolled bill, not the engrossed bill, but the enrolled bill. The enrolled bill will show what the new law looks like, but won't show changes. So I suggest that you have this handy, and if you're at home and can look at it or print it out, I will be referring to it. I'm speaking today because I'm filling in for former chief family court judge, Deanna R. She had some medical issues in her family and asked me to fill in. The revised summary that I showed you, I used to present to the family court judges, and she was going to do some modifications to that. So as I go through, I'm going to talk about a modification with comments on it. I'm going to tell you what I'm going to go through my presentation, and from time to time refer to what Judge Rock said and the comments that she made on it. Now, when I first presented to the family court judges and to you, I said, well, do you want to know all the wonderful dynamics that took place at the legislature, or do you just want to know the changes? And they said, well, we don't want to go all that legislative history. And in fact, that's probably appropriate because in West Virginia, there is not really legislative history. But Congress has committee reports that are often used to explain the effect of the bill. But we don't have those in West Virginia because that gives power to committee chairmen, and the rank and file legislators don't like that, so we don't do that. And you can still, I have from time to time, particularly now when you have all the sessions on YouTube recorded. I have on occasion or two said, look, this is the argument that was made by the chairman to get them to vote for that, and so that's what it means. And so so you should interpret the statute my way, but of course that doesn't mean that's how why the Senate voted for it. So there's not much legislative history, but I am going to give you some background to explain why some things are in here that are odd. So I'm going to have to give you a little just for that purpose. I'll tell you some of the whys. Now I want to lay my cards on the table early. I was opposed to and fought vigorously against House Bill 2363, both in its original introduced version and in the version that came out of the House. And I do that because I cannot help myself when presenting on by giving a little prejudice, though I will try to be balanced. So I just wanted to tell you that too. And in a sense, I feel disqualified to be here, particularly after listening to Judge Keller, because in 2008, I retired from legal aid, from frontline doing actual divorce cases. So listening to Judge Keller explain all those cases, I realized maybe kind of why. But I do feel qualified to be here because from 1975 to 2008, for 33 years, I did divorces and I did custody battles, and particularly domestic violence cases, always representing low-income people, almost always representing women. And for that entire time, I did legislative advocacy. So I do have that deep understanding of what's going on here. And again, my prejudice would be the model of custody that we had for a number of years, which was the American Law Institute, the presumption that the presumption should be, you look at who did caretaking before the separation, and that's how the time should be divided afterwards. I mean, it probably should be tempered for the workaholic dad or the two-job dad that he saw himself as making money for the family. But I've also learned in all those years that the best predictor of human behavior is prior human behavior. And I had so many cases where 2 years later, the mom would come to me and say, you know, reformed dad isn't coming to pick up the child when they should, and the child's crying, and what do I do? And she doesn't want to reopen the case, even if it improves her child support, because it's going to be another family feud. And if she does that, then he'll have incentive, oh, I will take the child, but she didn't really want in the first place. So my prejudice is for the ALI model I'll talk about briefly. In a sense, I should give you these statistics. When does the standard really make a difference? Our judges said in 90% of the cases, the parents come to them with an agreed division of custodial responsibility, decision-making responsibility. And 10% of the cases are what they call high conflict. And the other side would argue, well, the reason that they come settled is because there's this presumption of caretaking, and so that's not really a fair statistic. But when I look across the country, the same thing is true. About 90% of people figure out their work schedule, the kids' school schedule, and do it. 10% are high conflict. 50% are pro se, which also has a big impact on how things happen. But do let me give you, please, some history of child custody so you understand how we got here. When I first went to work in 1975, the standard was best interest of the child. Judge, you decide, circuit judges back then, with special commissioners, you decide what's in the best interest of the child. That's how you decide who gets custody and who doesn't. And that sounds good. Best interest, you could argue that. Well, it was awful because the consequence was a family fight, a family feud that often lasted into the future. She's too easy. He's too strict. If she gets him, he'll be able to stay with his mom who drinks too much. He'll let him run with this bad crowd of nephews. He spanks her. He spanks the child. I never believed in physical punishment. His mom will take it to the, you know, all this stuff was happening, and it made for a family feud, which often carried feelings when people should be learning how to get along, just turned into a battle that lasted. And the other thing, it was uncertain, so it was made a bargaining chip, happened a lot. Somebody who really didn't want the child custody would ask for it because they knew the other parent was so desperate to have custody that they would give up on alimony, they would give up on equitable distribution, even back then on child support. So it was a terrible thing. So, but along came in 1981 the Garska decision by Justice Neely, and what it said was based a lot on the fact that it was the family feud problem and the uses of leverage. What the Garska decision said, well, whoever was the primary caretaker gets quote unquote custody, which is not only primary time of the child, but all decision making. And the other person gets quote unquote visitation, which turned into a visitation schedule every other weekend, half the time in the summer, half the holidays, et cetera, et cetera. And the custodial winner got all the decision-making responsibility. It was based on a theory of child rearing called monotropy, that the first 2 years the child should bond particularly with one parent, take the mom, and that if the child learned how to do that well and wasn't spread out with a bunch of people, it would learn better how to have relationships with people throughout its life. But it turned out, it really was too cookie cutter for modern families, where fathers did more and more and women worked more and more. And then along also came the child support formula, where overnights determine child support. So there's a lot of pushback at the legislature. First, a group came that were mostly the second wives, didn't like what happened to child support. But then in 2000, 2001, a well-financed group, fathers' rights group, came asking 50-50 presumption. And what happened then was a highly distinguished legislative staff member named of Mike Mowry found the version called the American Law Institute, a several year study, lots of distinguished people, half men, half women, came up with the standard that we evolved, that we got, which was the caretaking presumption. you looked at how much caretaking was done by each parent before the separation. That's how much time they got afterwards. But it was a custodial responsibility. It wasn't custody and it wasn't visitation. So there wasn't a winner and a loser. Custodial responsibility was divided. Decision-making was also presumed to be 50-50. So presumption of decision-making 50-50, custodial responsibility divided according to how much caretaking was done beforehand. And that lasted from 2001 until just a couple of years ago, 2017. The gentleman who financed the original battle that came out for 50-50 that resulted in the ALI standard. His son became to the legislature, and a National Fathers' Rights Organization again began pushing 50-50. And in 2017, there's no longer a presumption of caretaking, but caretaking is a factor to be considered. That's kind of the law was before this year, and I think it continues afterwards. So along comes, and I think I am, as I say, I was very much opposed to this 50-50 presumption for two reasons. One is the historical people that don't want 50-50 are really going to use it as bargaining leverage for other issues. And two is the domestic violence I've done. The proponents of the bill said in Kentucky, they passed 50-50, but 50-50 can be ignored totally in the discretion of the judge. And they said the number of domestic violence filings went down. People must be getting along. And we said, no. Victims of domestic violence, when they learn that their children will spend half their time alone with their abuser, are going to stay in abusive relationships. So, what passed this year did not include the presumption of 50-50 in any form. So I now will go through it, and I'll be referring to pages here as I go. I'm going to be following the outline as set up in this document, and away I go. I appreciate the higher podium. Patricia, Judge Keller is either a lot shorter or has better glasses, but I really need this higher podium. First of all, pages 1 through 3 of this has 4 new definitions. The definitions are shared legal custody, sole legal custody, shared physical custody, sole physical custody. And what's really weird about that is those terms are used nowhere in the bill. Those 4 definitions are not used in the bill. They are not used in current code. And as Judge Rock's comment was, didn't like going back to the terms custody as opposed to custodial responsibility because it brings the winner-loser thing back into it. Now, there may be people who will argue that, well, but as those terms are defined or used in other states or by other Supreme Courts, it does mean 50-50. And I would submit to you that if the legislative intent was not to do that, or they would have said it. And the other argument will be, well, these things must have some meaning to be in there. Why else would they be in there? And the answer is, oh no, the legislature does not necessarily know what it's doing. And I'm going to give you not only this example where they put in 4 definitions that aren't used, but some others as we go along. The legislatures do things that don't have an effect. And the next thing that I'm going to talk about is on pages 3 and 4 of the bill that I showed you. Venue for custodial allocation actions independent of divorce. The family court judge is really distressed by this. There's a Uniform Child Custody Jurisdiction Act where there's an interstate decision of what state hears it. In the case of a divorce, there's a statute for venue of where divorces can be heard, and the custody and divorces are heard those. But there is no statute that says if they were never married, where's venue for deciding what county the divorce will be heard in. And there's a lot of forum shopping that goes on, and a lot of battles between a lot of judges between themselves trying to decide where to go. So that provision was in the bill that passed the House. Though the last night of the session, it got taken out. So what you have in there is a new section of code that says, guess what? That for interstate battles, you look at the Uniform Child Custody Jurisdiction Act. And for divorce actions, you look at the divorce venue statute. And doesn't solve the other problem. And so essentially another statute, another part of the bill that does nothing. A number of places throughout the bill, it will say orders have to include very specific findings of fact. And I was glad to hear Judge Keller mention that in one of her cases about the Supreme Court saying the need for this. Everyone on all sides of the argument said there aren't enough good findings of fact made in these cases. And for one thing, it made people not understand why they got what they got or didn't get what they didn't get. And that made it difficult for them to understand. Another thing is it made it very difficult to appeal because it's hard to overturn a judge's finding of fact. But if the fact wasn't found, or if the conclusory fact, not the facts behind it, wasn't found, very hard to do. And I think also some parties thought, well, they'll just put the findings of fact in there, then I have to win, and I lost. But one way or another, there's a lot of pressure, and this was said to judges at the training conference. You know, make more better findings of fact, and which means, of course, you lawyers out there, when the judge says you prepare the order, is going to want to make you prepare more detailed findings of fact. Please do so that people understand more what happened. Okay. There's a section of the code. I'm on page 8 at the bottom, a new section of the code that says that in the absence of an agreement, that the final hearing shall not be conducted exclusively by the presentation of evidence by proffer. Some parties of this view of the legislature hated proffer being used. They didn't get to put on their case. So you think, well, is that something new? No, because Rule 20 of the Family Court Rules says that the final hearing cannot be based on proffer evidence. So that's another time when the bill does not really change anything. You can look at Rule 20. If you look at Rule 20, but 9206E says simply the same thing. And you know, your sympathetic people just feel they didn't get to put on their case. They thought, or sometimes it's because they're mad at the other person and wanted to be able to say bad things about the other person. Or I had one friend that quit doing domestic relations cases when he thought he did a really fine job for a client. And he said, you did a terrible job, you didn't make her cry. So again, I think you'll find judges willing to do a few, I hope you'll find judges doing a few less proffers, or at least doing a better job on the findings to show exactly why, because, you know, why should you be able to put on a case that under the law means you would lose? And I understand where judges are coming from. Solve that by good findings. Now, does it in fact make some change in the custodial responsibility standard for in final hearings? I'm on page 3 of my outline. This is on page 8 of the strike and insert statute, of the underline and strike through statute. And there was an amendment to 9206 sub C, and it says, if either parent or both has demonstrated reasonable participation in parenting functions, a lot of taking care of the household, etc., the court cannot rely solely on caretaking functions and shall consider the parent's participation in parenting functions. This is page 8 in the middle. So what does that mean? Well, what's really weird is that subsection C only applies if you can't make a determination of custodial responsibility on subsection A. And subsection A used to have the presumption in favor of caretaking, but it no longer has the presumption in favor of caretaking, but it does have a whole list of other items to look at. So, and if subsection C does apply, then it doesn't have that whole list of 13 items that subsection A has. It says you look at the child's best interest. You've heard me talk about that problem. Subject to the limiting factors, you know, abuse, interference with visitation, and based on a subsection D in the relocation statute. Problem with that is that it refers to a subsection of the relocation statute that got re-lettered or moved around in the bill. So if you read that exactly, it doesn't make sense. But I think on page 16, a third of the way down versus page 19, a third of the way down, you can compare them. And I think if you rely on what the old statute said as being the standard to be used, I think you'll be okay. I think the courts will quickly realize what happened. So I've gotten way down in the way down in the weeds. What does this change in 9206C mean? I think that even though it doesn't technically apply if it's not A, I think it somehow it contributes somehow to the overall interpretation of the article. That caretaking is not a presumption, which it hasn't been for a while, but a factor, and parenting functions, other things that other than just changing diapers, do get some consideration. And Judge Rock's comment was that look at parenting time is important for the parties that agreed that one party would stay at home when you had a stay-at-home parent. Then it was particularly unfair not to consider parenting time somewhat, in her opinion. I added that factor. Now, in my outline, I showed why caretaking is still an important factor left in the code. And there are 1, 2, 3, 4 sections, page 6 at the top, page 5, but probably not worth flipping through the code section. Read, if you would, my outline on page 3, heading on caretaking is still an important factor left in the code to make the point that the legislature still felt that caretaking was important. It's no longer a presumption. A new thing added that wasn't in the code before, on page 7 now, is that time spent with third parties should not be taken into account when looking at how much time was spent with the parents, how much caretaking was done before. And I think that was to deal with the problem where, in fact, one party would get custodial responsibility and not really take care of the child, but give the child to, I'll use the male example, let the girlfriend do all the caretaking while the male was out doing something, or let the grandmother do all the caretaking. Now, Judge Rock would say, now, if that caretaking is done as daycare for while a parent's working, then that shouldn't make a difference. But the legislature felt very strongly that custodial caretaking means caretaking done by the parent to the extent possible. Okay, I'll talk to you first about does caretaking mean less in the final order. There was also a change on caretaking in the temporary orders. And in the criteria for a temporary parenting plan, I'm now on page 5 at the very bottom, section 9204, has new language, well, adds a couple words. It now reads, which parent has taken greater responsibility during the last 12 months for performing caretaking, new language added in, and or parenting functions relating to the daily needs of the child. So in the temporary custodial responsibility section, in addition to who performs caretaking, it says also parenting functions related to the needs of the child. So, and I think what happened a lot is they're just some pretty quick and based on proffers, temporary custody orders that end up getting there for months and months and months and months and months, and give you an outcome that might not otherwise have happened. So I think there is certainly an argument that the new code means parenting functions should be given more weight than before. However, I would note that the caretaking functions still has weight, as noted in my outline above, all the places where caretaking functions appear in the code. And also, even in the temporary allocation of custodial responsibility, it says, which temporary parenting arrangements will cause the least disruption to the child's emotional stability while the action is pending. So I think there's a little more authority in the code for temporary, for paying less attention to caretaking and a little more to parenting functions. The caretaking function still remains very, very strong. There was a change to investigations. Say I'm a little out of practice. I guess these are sometimes done by guardians ad litem, sometimes done by just investigators. I'm on page 13 where there was a lot of changes made. The original bill was very restrictive on the ability for judges to order and use investigations. There had to be advance notice. Well, that's okay. Had to say, what is the object of the investigation? So like they had to know what they were looking for before they went looking for it. And it forbade any action personal to investigative report until after a full-blown hearing. So an investigator can go back and say, pretty good evidence there's child abuse of some kind going on. Under current law, the judge go, whoa, and we're going to refer this to the circuit court, and there's going to be an order that says this potential abuser doesn't get to see the child anymore. But fortunately, those did not make it in, but some changes did make it in. It does require notice to the parties of that there will be an investigation, who the investigator is. And it makes it much more subject to discovery, including a pre-hearing deposition of the person doing the investigation. And if a party doesn't get a copy of the investigation 10 days in advance, automatic right for a continuance. So that may bridge into the court's right to set procedural rules. And perhaps the most problematic is it requires all records and documents reviewed or relied upon by the investigator be available to the parties. And what concerns me there is an investigator may talk to someone who says, you know, there's a real problem, but I'm not going to tell you about it unless you promise not to reveal who it was that tipped you off. The investigator says, okay, right now says, okay, I agree. And then uses that tip to talk to someone else or get other evidence that there's a problem. And right now that would be discoverable, that would be usable. Perhaps under the statute as written now, I would have to give this person's name up too, if I'm the investigator, which means that probably I might not get that information. Now, it's somewhat in relief to that. There is Rule 47D of the Rules of Practice and Procedure in Family Courts, Appendix B, Guidelines for Guardians ad litem. And that may conflict with the statute and give the guardian ad litem a handhold to say, I'm not going to tell you about this person, but this evidence you're going to get to see. And you know, you should be told of what real evidence is out there at some point. So that if you're into investigations, you need to read that code section carefully and Rule 47D. A big issue because an important legislator is if there are half siblings, half siblings, trying to coordinate visitation so that a child from the second relationship would get to have a relationship with a child from the first relationship. But the original bill as introduced said that because it was a 50-50 bill, said that the court had to match up those 50-50s so that the 50-50s had to have it together when one parent got both children, each for 50-50, they had to get both children at the same time. And I mean, current law is very lax. I don't even say it's lax on this, because what it says is in 9206A, that's page 6 at the bottom, 9206.3, sorry, I guess it would be, as one objective of the allocation of custodial responsibility, keeping siblings together, but only when necessary to their welfare. Pretty high bar to get for a judge to order over another parent's complaint, spending time with a child from a previous relationship. So there's now a new, on page 3, line 13, a new subsection added under objectives, best interest of the child. It's under the objective section, not the custodial allocation section. But there it is, and it says one of the objectives is meaningful contact between a child and his or her half-siblings, including half-siblings, serves the child's best interest. And can be hard to argue with that. The Judge Rock said this is going to be tough to try to match them up. For one thing, there may be a different judge in a different county, a different previous order. And think of people's schedules, different kids have different school schedules, different parents have different work schedules. You're going to have at least 3 parents, at least 2 kids. So it's a very difficult thing to do. But I do, and I've always thought, maybe a parent wants to have alone time with each parent and not necessarily have them both together at the same time. And they may fight like cats and dogs. I think it's a worthy goal to make sure that if there's the opportunity for half siblings to spend time together, and I think that's kind of an object of the bill, though it's not as thorough as the advocates would want. I think it will make judges think about it more, but they are going to be pretty much stuck if they don't have both orders. Page 7 at the bottom, a new objective is electronic access to the child. And I don't know of any judges that have ever denied, say, no, you can't have your kid's email or TikTok account or Facebook. But it's definitely in there now that as part of the parenting plan, there should be electronic access. Relocation. Every judge I talk to says they are the most difficult things for them to figure out. When a parent relocates for one reason or another, is it a good reason or not? Does it really affect the child? And I'm not going to review it. One, because it's probably an hour session all by itself. And the other is because I think that the rewrite is terrible. The basic takeaway is under current statute, the relocating parent gives a notice to the other parent, and the burden of going forward is for the other parent to file something in court and say, no, I don't like this, want the judge to look at it. Under the new statute, the relocating parent has to file in court. They have to be the one to start the proceeding. If you're looking at the statute as I presented, the old one is on page 15 to 17, the new page is 17 to 20. And it's just terribly written. You have to file it 90 days advance, but not serve it 60 days in advance. What sense does that make? And that's a long time in advance. And there's a section that says, except in extraordinary circumstances, a relocation may not be considered by who? The court or the person? Until an initial permanent parenting plan is established. What's an initial permanent parenting plan as opposed to a non-initial permanent parent? The statute is poorly written. I have preached to the Supreme Court, and I think they accepted. They're going to have to come up with some forms that try to make some more sense about this. And I think one of the most difficult problems will be, if suddenly one of the parents gets a job offer in another state, they're not going to be able to wait 90 days to go get it. And is that an extraordinary circumstance? I certainly hope the courts find that. They might have to act more quickly on this. And there's still very difficult things. But again, the takeaway is the moving parent has to file in court. And then good luck reading through the statute, but hopefully Supreme Court reforms will help us make sense. On page 9, line 16, a new change on the only change made to the allocation of decision-making, for which there's a presumption of equality. The issue that came up is you had one parent that would just ghost the whole situation and disappear for 3 years, 4 years, and then suddenly come back and say, hey, I want to make decisions about what school they go to, is there homeschooling, what medical decisions are made. And some people thought there might be a coincidence. That's when they finally started collecting child support. Suddenly that person took an interest. But it didn't seem fair for a parent that had ghosted the situation to suddenly come in and start making trouble. So a provision was put in by agreement for about everybody that says that the equal decision-making responsibility presumption goes away if there was neglect or abandonment by one of the parents. There's a new section. I'm not even going to give you the page number. New proviso in section 1.220 has to do with healthcare decision making, which is not different from section 9.207C. So again, I'm giving you 3 or 4 sections where what the legislature didn't make a difference. And if someone argues that the legislature must have meant to make a difference, no, there are 4 sections you can look at, which will show that a lot of times it didn't make a difference. Another difficult area is, I'm on page 10 now, what I'm going to call parental rights interference, sometimes colloquially called parental alienation. Though it's clear there is no such syndrome. And I will tell you that the judges were trained on this, and that, again, there is no syndrome, and the judges were trained on what questions to ask to try to determine if there really is, and sometimes there is. In my view, a parent will use a child to get back at the other parent. But sometimes a parent will also just do inappropriate things that alienate themselves from a child. You know, if they start inquiring into the other parent's social life. Probably the most famous one is Alex Baldwin. You remember he had a recording where that was on his daughter's phone, or imagine a 12-year-old missed a phone call, and he starts out saying, "You've really embarrassed me." Notice where the focus is not on the child, but you've made me appear to be an ass, and I'm humiliated, and your mother is terrible, and you've made me feel like a fool, and you, child, are a rude, thoughtless pig. Now, I would argue that child's mother did not alienate the child from that father. I would think it's the father, but it's a really tough thing to deal with. As practitioners, I would simply say that if when the child goes in to talk to the judge, if the child does feel alienated, the child needs to feel that they can explain that to the judge, why it happened. And I don't think I want to go any further on that. It is tough, but there is a new section. I'm sorry, there is some new language on page 10, because it used to just say interfering with access, has interfered persistently with the other parent's access to the child. Now it says, where the parent overtly or covertly persistently violated, interfered with, impaired, or impeded the rights of the parent or a child with respect to the exercise of shared authority, residence, visitation, which doesn't occur anywhere else in the code, or other contact with the child. So it's a little broader than old access. And as I say, a difficult thing to deal with. Make sure the child is prepared to explain why, someone's prepared to explain why the child might be alienated without the other parent having known it. Some little stuff on page 22. There's now will be a requirement that if the child is alleged to be a victim of a crime, then the other parent needs to know about that right away, unless it's the other parent that's accused of the crime. And I don't think there's going to be any problem with that. And then who the investigative agency is, you're going to see that in parenting plans. I see no problem with it. No, there is no retroactivity. One of the big issues in the original 2363 was that this new 50-50 standard, and it was a standard that said, I'll explain it in a little more detail later, that the 50-50 standard could be used to reopen all previous custody orders in West Virginia for the last 18 years, not to reapply the new standard. That had lots of just logistical problems from the judge's point of view. A lot of why are you restarting wars, and reminding again that only 10% of custodies are high conflict. But there was even an amendment at the last night of the session where they tried to make a change that some thought might make it retroactive. I don't think any fair reading of the code says it's retroactive. My last comment is going to be is what was not in the code, because those of you that followed it may have heard some things were in the code, and it does not. One thing it does, right now in the code it says that the child's best interest comes first, fairness to parents comes second. The 2363 took out that making fairness to parents secondary, but that stays in our code. Again, there is no 50-50 presumption that would tie the judge's hands. Even in temporary, where it said there had to be a document, all evidence or record which the court relies upon, that the presumptive 50-50 division would endanger the child's physical, mental, or emotional health. Again, Kentucky had a 50-50 presumption, but just said, judge can go, nah, in my discretion, I'm not going to do it. In this case, it would have been 50-50 unless it could be shown it was going to endanger the child's physical, mental, or emotional health. Same is true for full-time and temporary orders. The original 2363 said there'd be a full adversarial judicial hearing for temporary orders. That might be fine if we had twice as many judges, but that can still be by proffer. The final hearing cannot be totally by proffer. Again, in that 50-50 presumption, I talked about what I think is a danger for abusing and staying in relationships. Doesn't give the bargaining chip that happened before Garska with the 50-50 presumption. The original bill, I explained, required if there was different parents and half siblings, required each to get 50-50 and be there at the same time. That didn't make it. There's some encouragement about it. It didn't make all the changes to investigations that I talked about. It does not, as the original 2363, put false statements in the code about what the originals, about what social science says about parenting. And again, it does not allow 18 years of existing child custody orders to be reopened, which Judge Roth's enthusiastic comment would be a huge problem. So those are the changes. Again, there I did the summary, and again, I think you'll find most useful the strike and insert provision that I gave you. Will be easier to understand than looking at what is currently appears on your research, whatever you're using online or hard books, and the enrolled version on the website will not be helpful. This will be helpful. So,
David, thank you. We are halfway through, or just a little bit more than halfway through our reporting period. And Angie Volk is going to, our CLE coordinator is going to speak with you very briefly about that. In the past, and I want to make this clear to everyone who's listening, in the past, there have been extensions upon extensions upon extensions for CLE. This year, because of some changes that have already been made and some changes that have been presented to the court, which they have informally told us they think are good ideas, the reporting periods will not be extended into October, November, December. When it says June 30, you're going to be looking at June 30 of 2022. So Angie's going to address that and a couple of other issues. And she's going to take about a 5-minute of your time up here now to explain some of those things to you.
Thanks, Anita. So as Anita said, today I'm kind of your friendly PSA concerning pro bono CLE credit. Under new CLE rule 6.05F, attorneys can earn pro bono CLE credit for hours worked at entities that are named in the CLE rule. These include legal aid, the State Bar's Free Legal Answers Program, and Tuesday Legal Connect. You cannot get CLE credit for pro bono work at any other organization. The entities in the rule report your hours that you work to the State Bar, and your hours are converted to CLE credits based on a ratio of 1 CLE credit for every 3 hours that are worked, as outlined in the pro bono CLE credit rule. The maximum number of pro bono credits that you can earn during a 2-year reporting period is 6, and there's no partial credits and there's no carryover of pro bono credits. A little background, if you're not familiar with a couple of the programs that are covered by this pro bono CLE credit rule. Tuesday Legal Connect, or as we affectionately refer to it as TLC, is run by Legal Aid, and the attorneys basically come in and work a 2-hour shift from 6 to 8 p.m. on Tuesday evenings, answering live calls from people with legal questions. The program used to be done live at the Legal Aid offices, but due to COVID, they've set up a remote call-in system, and they are at this time planning on continuing to do it by the remote system. So attorneys get logged in, they take the calls, and they then fill out a form about each call that they took and what advice that was given, and turn those in to legal aid so that those hours can be turned into the state bar. The CLE Commission recently approved that 3 pro bono credit hours would be awarded for working 1 shift at Tuesday Legal Connect, taking into account the time for getting logged in and completing the forms, as well as 2 hours of actually taking phone calls. So if you work even 1 shift at TLC, you will earn a pro bono CLE credit. We encourage you to work a couple of these shifts or even more and earn even more pro bono credits. And you can contact legal aid to get started in that program. Free Legal Answers is a program that's funded by the ABA and it's run by the state bar. It's essentially an online forum where people can submit legal questions that are later answered by attorneys. Attorneys who are part of this program are given a login for the system. They can check the question list and go in and answer as many questions on that list as they wish. Attorneys are given the person's name and contact information. They send them an answer, and they can even attach documents if that would help answer their questions. Our IT director, Mike Mellis, is willing to help attorneys walk through this system and get them familiar with it. And he can also help attorneys subscribe to just a certain category of questions if you want to narrow the questions that you want to answer down to your specialty, which is one of the reasons why we wanted to speak to this group today, because a majority of the questions are family law related issues. So the folks here in the room and on Zoom would be ideal candidates for helping us with this Free Legal Answers program if you would be willing to do so. Your pro bono credit hours are calculated based on the amount of time that you spend answering the questions. So the bottom line is we highly encourage you to do pro bono work, both as a means to give back to folks who may not have access to attorneys through another means, and with the added bonus that you can earn CLE credit while you do so. And as Anita mentioned before I came up, the Supreme Court is under consideration of a new suspension process for CLE, and that June 30th deadline is going to be a much firmer deadline. So this is just an added way that you can earn CLE credits and meet that deadline.
Angie, thank you. We are going to take a 5-minute break. So those of you who are online, please just walk away, leave your computers on. In 5 minutes, we are going to start on the new topic of evictions, and Susana Duarte and Katie Marcum. So we'll be back in 5 minutes.
Susana, if you would like to go ahead and share your screen, you can go ahead and get that started.
Mike, is it sharing?
Yep, that looks good.
All right, fantastic. I'll stay muted till we're ready to go.
Yep, Anita will let you know here in 1 second when she's ready to stop the screen to get started.
We are ready to start our presentation on evictions. And I'm going to turn it over to Susana Duarte and to Katie Marcum to introduce themselves and to give us a good education on what everybody needs to know in light of this moratorium ending the end of this month. Ladies, you are on.
Thanks, Anita. My name is Katie Marcum. I'm an attorney at Legal Aid. I work in the Elkins office. I'm also Legal Aid's statewide housing task force leader. So I provide support and direction for attorneys in our program who handle private landlord tenant evictions and also federally subsidized housing matters. As Anita said, we are looking at the end of the federal moratorium on evictions, and we're expecting an uptick in evictions as that happens. And so we thought this would be a good opportunity to introduce folks to the basics of landlord tenant law in West Virginia. I'll turn it over to Susana.
Hi, all. I am Susana Duarte. I am the Legal Services Manager here at Legal Aid of West Virginia. I've been an attorney with Legal Aid of West Virginia for nearly 16 years, as I was doing the math this morning. And I've done some version of landlord tenant work the entire time that I've been here. I've focused a lot on subsidized housing law, but have had the pleasure of working with folks across our state doing this kind of work and other kinds, lots of family law and domestic violence work as well. Katie and I are so excited to be presenting to you in the third hour of a 3-hour training over lunch. I am sure that you all are very vested in learning about this. And quite frankly, we're really excited to share this information with you, in part for selfish reasons. We hope that you're going to take this and want to do something with it as well. I'm going to take just a moment to talk a little bit about legal aid. Angie just did a great job telling you about some other opportunities to help folks. And one of those organizations that you can do those hours with is Legal Aid of West Virginia. We are the nonprofit law firm serving all 55 counties with 12 offices across the state. We do only civil legal work. We are an umbrella over a behavioral health program and an ombudsman program in addition to our legal work. We're doing pretty great stuff across the state with really interesting projects. But today we're going to focus in on one area of law in particular. And the reality is there are many more eligible West Virginians for legal aid services than we are able to represent and provide direct services to with the attorneys that we have. So we very much appreciate our partners like the Bar with Free Legal Answers and TLC and volunteer attorneys who take on cases in any number of clinic settings or direct rep or advice. And so what we want to do is provide you all the tools to feel confident in that work. And quite frankly, landlord-tenant law is a great place to do that because you're all lawyers, and landlord-tenant law is contract law, which you all took. I know you did. So we are going to do that today. And we're going to just kind of walk through. We've got 50 minutes. Believe me, Katie and I could talk about this for like 8 hours. So we're just going to really cover our bases. We're going to just sort of give you all the places to look and give you kind of the overview of what to expect and kind of hit some practice tips as well. So again, our focus is landlord-tenant law. We're not covering commercial realty, land purchase. We're not covering non-tenants, RTOs, or subsidized housing. Now, we are very briefly going to tell you what subsidized housing is at the end, just because knowing that is relevant to being able to do the work and in terms of issue spotting, but we're not going to spend a ton of time there. So first, lease. Let's make an agreement. A lease is the contract, right? The contract tells you what everyone has to do. It creates the legal terms between the landlord and the tenant. A lease in West Virginia cannot waive the warranty of habitability, and it cannot waive the statutory security deposit requirements. A landlord can't retaliate against a tenant for exercise of those rights. And there are both state and federal laws that we have to look at when we are considering landlord-tenant work. So first, what are the landlord obligations? Follow the lease. Very simple. Do what you say you're going to do. If the landlord says, I'm going to replace your carpet, the landlord should then replace the carpet. Another big one is reasonable notice of entry into the unit. You would be surprised at what a very significant issue this is for many folks across the state. The sort of principled idea by the landlord, well, it's mine, so I can come in whenever I want. No, you cannot. The possession of that unit is in the tenant's hands, and the tenant is entitled to reasonable notice of entry into the unit, absent some emergency. So unless there is, an active pipe burst, there is no reason that a landlord needs to barge in, let themselves in with a key, or do anything else that would infringe upon the tenant's right to quietly enjoy their own property. Now, what is the warranty of habitability? This is a big one. This is a place we see lots of cases. This is incredibly fact-driven. There's lots of things you can think about that fit under this umbrella. There's two places you're going to look in terms of the law. One is statutory. The code section is 37630. It requires that the landlord deliver and maintain the property in a fit and habitable condition. That includes electric, plumbing, sanitation, heating, ventilation, water, hot water, all the basics that one would expect when they rent a unit for living in with themselves or their families. You would be surprised, again, how many cases we see where these things are not delivered and are not maintained. These are real problems that many tenants face across our state. There is also a significant case that sort of speaks to warranty of habitability, Keller v. McCoy. So what is it? What's the habitability issue? It's a material defect known to the landlord that either comes to occur while the tenant resides there or it exists at the time the tenant moves in. The landlord does need to have reasonable opportunity to both know about the issue and to make the repair. But once that landlord has failed or refused to make a repair within reasonable time, what are the remedies? What can we do? So the first question is almost always, what if the tenant did it? The tenant's clearly the one who busted down the door or broke the window or did the thing. Well, if that's true, if the tenant did cause the damage, the tenant is responsible for the cost. The landlord might not have an obligation to make the repair, or the landlord may be able to hold the tenant liable for the cost of that repair, right? Broken window is an easy example of that. Tenant throws something, window cracks, landlord replaces, that's going to come out of a deposit. That's going to be a cost liable to the tenant. The flip side to that are all the other things, the lack of heat, the lack of hot water, ventilation issues, things of those natures. That's all going to fall back on the landlord. So what happens when the tenant's already behind, right? So the statute does indicate that if the tenant does owe rent at the time that the defect arises, then the landlord does not have an obligation. Unless, of course, the reason the tenant owes rent is because they're withholding it because the landlord has failed to make that repair, in which case they are withholding. We're going to talk more about that. And the landlord's obligation is not suspended. So what does the tenant get to do? Well, first of all, if the landlord really has failed to make these vital repairs, they've informed the landlord, they've told them about it, they've given them reasonable time, and the repair still has not been made, the tenant can move out without being liable for the remainder of the lease term, right? The contract length is situated as a term of the contract, and they would not be liable for the remainder of the term with evidence of this having occurred. They can withhold rent after communication to the landlord has failed to result in timely repairs. They may seek damages. They can seek affirmative damages with a lawsuit in court. Usually these are brought in magistrate court. That's based on the statutory requirements of the amount of damages that one is seeking. And the remedy is what's called a reduction in fair rental value, right? So our favorite piece of evidence is the advertisement. You know, what would you pay for a unit that's drafty, doesn't have hot water, and lacks heat in November? Name your price. And obviously that's going to be a little bit different if we're talking about having gone a month without hot water. Well, is it April or is it January, right? So the valuation might, again, is very fact dependent, and those are all things that you're going to be looking at when you look at these cases and you value them out. Now, quite frankly, most of the time these cases originate because the landlord has brought a cause of action, which is usually an eviction action. At that point, the tenant can also assert this as a defense. So they can assert habitability, assert a counterclaim with the same calculations. Now, what can't the tenant do? In West Virginia, we do not have a repair and deduct statute. That does exist in some other states, but not here. So that means unless the landlord specifically consents, then the tenant is not the one who should call the plumber and pay the plumber and then deduct that from their rent. Quite frankly, if I have a tenant who wants to do that, I would not counsel them to do it unless the landlord has put that in writing in a very clear contractual agreement, which never happens. So then we're looking at specific performance. Can the court make the landlord make the repairs? Quite frankly, the answer is usually no. Usually the remedy is that the court can set a continuing reduced fair market rental value until the repair is made, right? So until the heat is on, the tenant is liable for $100 in rent and not $1,000 in rent. And that can be continued to be paid into the court, and there's remedies situated there to be paid by the tenant until the repair is made. And the court can actually accept those payments into escrow during the pendency of the case. How do you prove these? This is the same way you would look at considering the merits of a case, right? So you're looking for evidence, and that is always at legal aid the issue in our cases, and for all of us, right? How do you prove this stuff? It's so challenging. Depending on where your client lives, maybe you have some outside third-party resources. Neutral party verification is obviously the gold standard. In Charleston, we have a building inspector, and they do a great job, and they will go out, they'll do a report, they'll identify and write these things up. But that's limited to city limits, right? So once you get outside into rural areas or even the broader counties, you know, who can you rely on? Sometimes issues are significant enough that the health department will actually do an inspection. I've seen the fire department do inspections and write things up when there is a significant safety issue, usually with fuse box or things like that. You learn a lot when you do these about how houses work. Utility companies, right? You can look at whether whether a water leak has occurred by looking at a water bill and looking at a year's worth of information, right? So if your usual June bill is $50 or $75 and suddenly your June bill is $500, well, something's going on, right? So you can look at those sorts of, look for that evidence that's going to support the claim. Obviously, witnesses or neighbors who've witnessed it, photos and videos can be very powerful and show some documentation of what's going on. And when you're looking for damages, another big issue is accidental evidence. So, you know, mold is a big issue that we see sometimes, and real damage to our clients' belongings, furniture, clothing, shoes. I mean, mold is, once it infiltrates, is pervasive. But if you've got, you know, you don't take a picture of your own couch, but you might have a picture of, you know, your kids sitting on the couch when they're playing a game. And so now you do have a picture of that couch, right? You didn't intend for that photograph to be evidence of your couch, but if that photo was taken prior to the mold, it's going to show some comparison as to the after. So think about those things when you're trying to evaluate these cases and you're looking at what the tenant's telling you has been an issue. The other issue, obviously, again, is the landlord has to be on notice. How do you prove that? Keep copies of everything, receipts, texts, phone logs, notices, leases. It's very frequently now that landlords and tenants are texting each other. It's great evidence, right? I told you that there's a leak and the landlord says, I am calling the plumber, and then nothing happens, or something does happen and maybe the tenant's being unreasonable, right? The evidence will bear that out. So look at those things, make sure that to preserve those things, and make sure we're talking to our tenants about what to expect when they have these cases and what their remedies might be. Katie, do you have anything to add? And if not, feel free to move on.
I do have, there have been a couple questions that have popped up in the chat, Susana, and I thought one of them is very relevant. So Liz asks, is there an issue with advising a client to withhold rent? She says she foresees that the landlord will file for eviction for non-payment. And Liz, the answer is yes.
Yes. That is how most of these cases play out, in fact. And so if you're talking to a tenant before everything has fallen apart, you want, the intervention often on our end when we're telling a client to play this out exactly the way we'd like it to play out is to put everyone on notice in writing, right? You tell the landlord that you're not going to pay August rent until X is fixed, and that you are going to put your August rent in escrow, right? You're not going to spend your August rent. You're going to keep it in the bank. You're going to do something with it to keep it safe. When we're involved in those cases, we'll hold those dollars in trust. So it absolutely, you are correct. That is how those cases often play out. And it is, therein lays the challenge, right? Particularly when we're dealing with low-income clients, they're having to make really difficult choices with fixed incomes. So, do you save that money to move into your next place? Do you save that money in hopes that your landlord will make the repair? In both cases, you want that your tenant hopefully saving those dollars and to have communicated clearly to the landlord. But the reality is the majority of these cases show up because the landlord hasn't gotten paid and they go to court. And the courts when the courts hear that money hasn't been paid, it is an uphill battle sometimes to make these habitability claims. Has that been your experience, Katie?
I was going to say, I would also say habitability is kind of an upward battle anyway, because in West Virginia and the United States, we have freedom of contract. And so for a lot of magistrates, the solution is if the property is not up to your standards and you don't like it, you should move. When we're dealing with low income folks, that's often a lot more difficult than, I rent and it would be difficult for me just to up and move, but it's also often very difficult for them to think about, new deposits and the cost of moving fees and new security deposits, that kind of thing. But to answer your question, Liz, yeah, that is absolutely something that I advise clients that come to me before the eviction has been filed. You should know that your landlord will file an eviction, and you need to be considering the evidence that you need to maintain, and you need to consider what your options will be, because that is very likely going to be the situation you find yourself in. Sabrina asked about essentially when folks own the home but not the land, I assume mobile home stuff. We're going to talk about that a little bit later, Sabrina. And then Kelly asked, are there any West Virginia laws on landlords recording tenants while inside the rental property? Susana, I don't know if you have an answer to that. I'm not aware of any laws that address that at all.
There's no laws. I think it's a reasonableness standard. I think I'd feel pretty comfortable with asserting a right to privacy, and that would not be appropriate. Now, if there's a security system on the front porch and everyone's aware of it, I think that's a very different standard than a landlord, placing a camera in a living room or, God forbid, a bathroom or something like that.
All right, Susana, do you care to move on to the next slide then?
Absolutely.
Okay, folks, so we'll just talk briefly about the ADA and the fair housing statutes. So landlords do have an obligation, even in private, landlord-tenant agreements, to reasonably accommodate the limitations of a disability, but those accommodations cannot be an undue burden on the landlord. Certainly a tenant who wants to rent the 7th floor in an apartment building that they know does not have an elevator, that they would not be able to access, cannot rent the property and then tell the landlord that they need to put in an elevator. There are also waivers that are available under the ADA compliance statutes for existing structures until substantial changes or renovations are made down the road. One thing that we do just kind of like to let folks know to think about is that service animals are protected under the ADA, the West Virginia Fair Housing Act, and the West Virginia Human Rights Commission Act. Service animals are different from emotional support animals. We do run into that a little bit, but just know that those protections are out there. And so Susana talked about what the landlord's obligations are. So what are the tenant's obligations? Tenants also are parties to the contract and they need to follow the lease. They also need to honor any promises that they made at the inception of the tenancy, and that includes paying rent. They have an obligation not to damage the premises beyond what is reasonable wear and tear. And they have a right to ensure quiet enjoyment for other people in complexes and that kind of thing. Tenants need to follow the lease provisions and any occupancy rules regarding visitors, guests, any additional residents, any kind of additional contracts or addendums to their lease. They're also responsible for making sure that that happens. So one thing that Susana and I wanted to talk about, I think Susana may pop in here a little with this, is that right now, there is an opportunity for tenants who are behind on their rent or utilities to get caught up due to the coronavirus pandemic. We have the Mountaineer Repayment Assistance Program, or MRAP is what they're calling it. It's being administered by the West Virginia Housing Defense Fund. There's a lot of money in there to help folks pay back rent, future rent, and get caught up on utilities. It is a win for everybody, in our opinion. It's gonna put money in landlords' pockets. It's gonna allow tenants to stay housed and get caught up. It's gonna avoid unnecessary court actions and avoid what could be a clogging up of our court system here as we look at the end of the eviction moratorium and thousands of cases that are currently kind of waiting in the hopper statewide to be heard for non-payment and eviction matters. There is an application for the MRAP program that folks need to complete and need to provide some additional kind of supporting documents. That's available online and there's some more information there. We also included a handout in the materials with like information about the MRAP program. And again, it's exciting from our perspective because it also assists with utilities payments. That's something that for low-income folks is really hard to find cash assistance for. So that is also available.
I just really want to reiterate that this is a resource that's come through federally. These dollars have gone nationwide. This money is allocated to West Virginia, and if it's not spent, it's going to go back. And there is a real opportunity here to make everyone whole. People lost jobs, businesses were closed. Evictions are not a new problem across the country, and certainly not new in West Virginia. The idea that there might be money to help solve the problem is novel. Folks, through no fault, and Katie's going to get there in a bit. We're talking about evictions, but I've told lots of people the court doesn't care why you owe your rent. It doesn't matter if your kid had to go to the hospital or you spent it all on drugs. The result's the same. You're evicted because you owe the money, and that's terrible. That's a person's home. It's a public health issue when folks have to move. It impacts health. It impacts education. And the idea that we have dollars right now that can make a landlord whole, right? Landlords weren't able to make repairs. They weren't able to pay mortgages. Landlords are also behind in the payments they planned for. Tenants, through no fault of their own, weren't able to make these payments. These dollars are available to make people whole and keep them housed. So it's a really big benefit. And if anyone has any questions at all, send them to MRAP. We have community navigators right now working with our program through the end of August to help folks do some applications for this as well. And I'll put that in the chat box, a link on our website about that information. But again, just if you are aware that money is a main issue with either utilities or with housing, please refer folks to this program. It's of huge benefit.
One thing, Susana, Liz has mentioned that she works for the AG's office and some folks haven't been able to reach MRAP. I know personally that back in April, it did take kind of a while to get it set up. I mean, we're talking about adding a whole new program and infrastructure. I haven't had folks recently that have had problems, and I know folks that have been getting paid. Do you have any comments about that experience, Susana?
I know from what we've been told that there's just community, the application's, it's not onerous, but there's a bunch of stuff they need, right? So there's a lot of follow-up necessary once the applicant has applied. So there's some back and forth required between MRAP and the applicant. So they do have a phone number. They've got a fantastic FAQ on their website. So I would say really the encouragement would be to reach out. And quite frankly, if you're having specific issues, reach out to us, reach out to Katie or I. We've developed some relationships with the folks administering that program. And if we're identifying some issue, we could put you in contact with the right people over there. But I think overall things are doing better, but it's not a one and done application. There's some follow-up, there's paperwork that they need, there's things they need to see. And so that does take some back and forth.
All right, I think we can move on.
In fact, Kate has just added some great contact information into the chat box.
Yeah, I see that.
All right, I will change slides, Katie.
Yeah.
Okay. Oh, maybe I will. There we go.
Okay, so we talked about what tenant's recourse is. What is the landlord's recourse if a tenant is breaching their obligations? Three kind of main actions that can be taken: ejectment, unlawful detainer, or wrongful occupation. Those are all a little bit different, and the code sections are there. The most common thing that we're going to see, and generally the most appropriate thing that we're going to see, is a wrongful occupation action that's going to be filed in the magistrate court process. This is going to be for non-payment of rent, damage of property, or breach of any leasehold covenant. So that's why it's going to be the most common thing that you're going to see. Again, unlawful detainer and ejectment, slightly different requirements for those, but generally what we're going to see is a wrongful, and that's usually the most appropriate action. So wrongful occupation under the statute is a really quick process. It's designed to put a landlord who has been wronged in some way back in possession as quickly as possible, if that is the appropriate remedy. So we're going to set the hearing at the time of the filing of the petition, usually written on the bottom of the petition by magistrate officials, and it is within 10 days. There's a jury trial available. Either party can request it, and it can also be automatically removed to circuit court on motion of the tenant if the amount of controversy is $2,500 or more. And that can include the value of future months of occupancy and amounts of any counterclaim as part of the amount of controversy. There's a case on that. It's Strickland v. Daniels. We've cited it there. And the rules of civil procedure do apply. The magistrate court rules do allow for some limited discovery, a little bit different than what would apply in circuit court. And the timelines can be shortened again on a motion for good cause, and the case is cited there as well. So what is the relief available in a wrongful? The magistrate's gonna hear the case, usually just hear from the tenant and hear from the landlord and make a decision that day. If the tenant prevails, the case is gonna be dismissed. One thing that I would like to highlight is West Virginia does have a pay and dismiss statute. So if the only thing that is in question is, or the only ground for eviction is non-payment of rent, and if the tenant shows up to the hearing with all the rents and arrears owed, including interest and costs, then the matter must be dismissed. The statute's very clear about that. That doesn't happen very often, so sometimes it can be a little confusing, but pay and dismiss is an option that we do have in West Virginia if a tenant shows up with all the money, and that's the only issue. If the landlord prevails, we're going to get possession of the property awarded to the landlord with an effective vacate date and time, and then a judgment would also be ordered at for any money that's owed for back rent or damages at the time of the hearing. If a tenant holds over beyond that vacate date, then the landlord is going to need to enforce that order of possession with law enforcement's assistance after the time and date indicated in the order. So sometimes we get a question, even from landlords, do landlords have to go to court to evict somebody? I generally think yes. I think that the legal remedy is to go through the expedited wrongful occupation action, where they could get possession within 10 days. Law enforcement generally will not assist in removing a tenant absent a court order that directs them to do so and gives a specific date and time that is appropriate. In West Virginia, the law is a little ambiguous about whether a landlord could lock out a tenant who has breached the lease, but my opinion would be that a landlord could subject themselves to significant liability if they initiate that lockout without utilizing the wrongful occupation statute. And the reason is because whether or not the tenant is at fault and has breached the lease is actually a legal determination that needs to be made by a magistrate or a judge. So I think that if that hasn't happened, or if the facts are maybe not as the landlord thinks that they are, there could be an issue there with liability on the landlord's part that I think would be avoidable if they had gone through the wrongful occupation proceedings. Next slide. So either party has the right to appeal the decision of the magistrate to circuit court. That code section is 5512 within 20 days of the judgment. It can be filed later than that if there's good cause within 90 days. A bond is required from the person appealing to post to do the appeal, but no bond is required of any person who files for a fee waiver affidavit. That's in the code, and also there's a case Baby Marshall from 2011. Sometimes that can be confusing for clerks or magistrates. So just be aware that if that person qualifies for a fee waiver and has had one approved, they do not have to post a bond. There's no other discovery that is available, and the court hearing is de novo. And what I would say is generally circuit judges are only going to hear information and evidence that was available to the magistrate. It is a new hearing, but it is a new hearing that is exactly the same as the other hearing. They're going to hear the same things. They generally won't take into consideration things that have happened after the magistrate court hearing and before the circuit court hearing. So who gets to keep possession of the property during the appeal? That answer is law school. That depends. There are a couple code sections and statutes which indicate that the judgment of the magistrate is stayed by the filing of the appeal. And that is an automatic stay, not granted on a motion, which would include in any enforcement of the judgment, such as obtaining possession of the property. However, West Virginia Code 553A3 says that during the pendency of an appeal, the tenant is not entitled to remain if the tenancy has otherwise expired. So that would be a situation where a lease would have expired, and the landlord had properly told the tenant under the lease, we are not going to renew this lease no matter what happens at this magistrate court hearing. The hearing goes poorly for the tenant appeals, but the lease expires. Under the code section, despite the fact that there is a stay that would typically allow the tenant to maintain possession of the unit until that hearing, the tenancy is otherwise expired. Again, if an appeal is taken and the tenant prevails on the appeal, the code section specifically notes that if the lease term has otherwise expired, the tenant cannot be restored to possession. Again, this is kind of just breaking down a little bit. Otherwise expired, the tenant can't remain in possession, and the tenant cannot be restored to possession. But if it has not otherwise expired, then possession is one of the things that the circuit court could award to a tenant who would prevail at a circuit court hearing. And termination of a periodic tenancy without a breach of the lease, or a tenancy that does not have a lease. A periodic tenancy would be no end date, month to month, year to year. You had a lease and the lease, went through the full year and then it goes month to month, that kind of thing. In order to terminate that, there are some specific requirements under the code for the landlord and the tenant. Notice has to be given. It must be in writing, 1 full rental period before the end of any period. So if you pay rent on June 1st or the 1st of each month, you need to get that notice to the opposing party before that first month. If it's a year-to-year lease, we're going to look at a 3-month notice. And because an eviction here is going to not be based on any alleged breach, it's just going to be because one party desires to end this contract, judges are going to be looking at really technical compliance with this one full rental period requirement. So we want to make sure that whoever determines that they would like to terminate a periodic tenancy knows that this is one of the requirements that they have to meet, and it is pretty strictly enforced.
This is definitely one of those where like people's understanding of the law is, oh, I get 30 days. And that is not what the law says. Now, sometimes everyone believes that, right? Sometimes the tenant and the landlord believe that, and it's to the landlord tenant's benefit, but that is not what, absent fault, it's this full notice period. It's a very specific reading of what the tenants and the landlord have been doing. All right. I don't think we have any questions in the chat, Katie. So now, quite frankly, you've gone to court, right? You've presented your case. You have gone before a magistrate. The magistrate has made a determination, and your tenant has either been evicted or the tenant has been told that they can remain in possession of the unit. Now, if the tenant's in possession of the unit, the matter is resolved and dismissed. If the tenant has been told that they have to vacate the unit, now it depends, right? Each county, I would say, is very different in terms of how they handle these. There are counties that provide very limited notice with regard to a tenant. There are some counties that provide 30 days as a matter of course. It really varies by jurisdiction. But one of the issues you'll encounter regardless is what happens to the stuff, right? So the vacate order is for possession of the unit. It means that the tenant has to leave and the landlord is restored to possession. It actually does not mean that the tenant's belongings should be set out. We are well aware that that often happens. It does not conform with the law. The landlord actually has a legal obligation to protect belongings abandoned by the tenant in both scenarios. One, where the tenant vacates the unit after a court-ordered eviction and abandons property, and also when a tenant vacates the unit without notice and without a court order but abandons the property. The landlord still has a legal obligation to protect belongings. Now, this gets fairly hyper-technical, and I'm not going to go into the nuance of this. This is sort of counter to what they tell you to put on slides. It's way too much information. But the reason we put all this information is it's hyper technical. And if you are dealing with this, you should read it carefully. But I'm gonna go over it just to sort of give folks an idea of what we're looking at. So if you're dealing with abandonment of property with a court-ordered eviction, right? So this means that everyone has gone to court. A magistrate has ordered a tenant to vacate the property and they've provided a date certain, and the tenant has now vacated, but their possessions remain in that unit. So at that point, the landlord does have some obligations. If the tenant informs the landlord in writing that what's left is trash, then the landlord can dispose of it without liability. Fine, no problem. The flip side is if the tenant doesn't do that, the landlord must safeguard for at least 30 days. Now, after 30 days, the tenant, they can get rid of the belongings if the tenant has not paid reasonable storage cost or reclaimed their items, or the cost of storage equals the value of the personalty being covered. Now, the kicker here is what the landlord cannot do is hold the tenant's items hostage until they have paid their back rent. So if a tenant owes 3 months of rent and the landlord says, well, I'm not giving you back your stuff till you pay the rent, that does not conform with the statute. They can charge reasonable storage costs, but it does not say that the landlord has to be made whole before they release the belongings of the tenant. The tenant, again, the landlord must store for an additional 30 days if the belongings are worth more than $300 and the tenant requests it and pays that reasonable storage cost. So for the most part, the landlord is liable for that 30 days unless these additional factors are met. Let's move to the next slide. Here we go. Now, the second scenario is one that avoids court altogether. This is where the tenant has abandoned the property. So the tenant's gone, right? The landlord comes in, realizes that the tenant is no longer in the property, and now the tenant, but the landlord needs to make sure that's what's going on, right? A tenant going on vacation for a week is not abandonment of property. So there are steps in place to protect everyone involved in this. So step one is that right to regain possession of the premises, post a notice in a conspicuous place, demand that rent be paid, during that period of time, and only then can the landlord change the locks or be entitled to recover possession. Now, in the scenario where the tenant abandons and does not safeguard the property, that might be a different scenario, right? So if the tenant walks out and leaves the door wide open, the landlord is going to be in a different obligation to safeguard their own property. That, I would argue, is different from this. What this is really meant to capture is the tenant who is vacated and abandoned, but you need to make sure that's what's happened. So again, the law sets out how to go about doing that. Step two, again, deals with the retention and disposal of abandoned property once that initial notice period has gone through. Again, conspicuous notice, forwarding to the tenants, making sure you're following those 30 days if the personalty is worth more than $300. Again, fairly hyper-technical. If this becomes an issue, it's important to take a look at it. A lot of the statutory change came about, quite frankly, with rent-to-own centers and places like that, places that were renting tenants, furniture or small appliances, and they were losing their personalty. So quite frankly, these were not written to protect tenants so much as they were written to protect others, but the protection affords both those protections. And quite frankly, following this law protects everyone from liability. That protects the landlord from liability, and it also would protect law enforcement from liability as if they're helping in terms of setting things out. So it's very important to be aware of this and to make sure that we're following these statutes when a tenant does vacate a property. All right, changing gears. There are a few things that you just can't do. One of those things is retaliation. So a landlord may not retaliate against a tenant for enforcing a right incidental to the tenancy. The thing that we see the most often, quite frankly, is the tenant who contacts someone because of a habitability issue. So the tenant contacts the building inspector or contacts legal aid and says, I've had no water, I have no heat. And that is promptly followed by an eviction notice. That's retaliation. That is not permitted by the courts. That is not permitted, and it's spelled out in the statutes, or excuse me, the case law that's cited to here. And again, this can be asserted both affirmatively as well as in defense to an eviction that's filed by the landlord. Security deposits. So we had probably one of the more recent law changes we've had to our landlord-tenant statutes has been the change to the security deposit statutes. So there's now a much more clearly defined process and methodology with regard to return of a security deposit to a tenant. So there may be some distinctions between there might be some additional protections in a federal lease than you might find in a standard West Virginia private landlord-tenant lease, but for the most part, obviously you're going to read those documents because we're lawyers, that's what we do. But in this case, we're just going to talk about sort of the standard fare. Tenant pays a deposit at move-in. What does the statute say has to happen? So the statute is pretty clear. You need to, follow it. You have 60 days from the termination of the tenancy or 45 days if a new tenant has occupied the property, whichever is shorter, for the landlord to return the deposit to the tenants. The landlord's obligation is to refund the deposit minus any deductions for damage beyond reasonable wear and tear or other charges as provided in the lease. And here's the real key. They must provide an itemization of damages and charges. And I think that absent that provision, if they fail to return the deposit, they are going to be subject to the penalties we're about to discuss. The landlord has to maintain records of those deductions for at least a year and has to permit inspection should the tenant wish to do that. So the key here is what's reasonable wear and tear. Obviously, that's fact driven. But if a tenant has lived in a property for 10 years, you're not going to charge them for painting the unit. You're probably not going to charge them for replacing the carpet. If a tenant's lived there 6 months and it was brand new carpet and the carpet's destroyed, that's certainly something the tenant would have to bear. So there's lots of facts that go into what reasonable wear and tear is. And those all have to be considered and they should be itemized. And, larger property management companies will actually set up like an itemization. So if a carpet has to be replaced, at 10 years old, it might be 0. At 9 years old, it'll be, 90%, et cetera. So some of those charges can be itemized based on how long the tenant was residing there and how old the carpet was. But again, it all has to be documented. The tenant has to be able to say that existed at the time that I moved in, or I reported that to you and you failed to make a repair and that's why it happened. So again, this allows for that back and forth. There's also some teeth to this. If the landlord fails to follow through, provide that documentation or provide the deposit back, the tenant can file suit and they can seek their security deposit plus annoyance and inconvenience equal to 1.5 times the wrongfully withheld amount. So there's actually some provision that makes this a little bit easier to enforce. Another provision of the statute also states that it doesn't matter whether the landlord is the one who accepted the deposit or not. That was another big issue that many of our tenants faced, where the property manager, landlord said, oh, I got this, you moved in before I took your property on. I don't owe you any deposit because, Joe Schmo had it from before and he never gave it to me. That is irrelevant under the current statute. The existing landlord is the one who has the responsibility to return the deposit. So some really solid protections here that are enforceable and clearly written out. I would add what Katie and I have been talking about, lots of different issues. Our website was actually just put out, we updated our website pretty recently. We have really great FAQs. They are obviously written for our clients or folks who are just interested in West Virginia law. They are across all sorts of issues from expungement to housing and family law. But a lot of these things that Katie and I are going over are also in our FAQs. So it's a great resource for you all, if you're looking for something quickly in terms of providing some additional information for folks. And it's a great resource to point people to as well if they just have a question, which is often what we encounter. Folks just sort of have a question about how they can proceed forward with something. All right, do we have any chat questions on this? I don't think so, do we, Katie?
I don't think so.
All right, so we're gonna now just turn it to some quick know the distinctions that Katie's going to go over next.
This is going to be super quick, just enough to know the distinctions. I just pulled it out here. I mean, the HUD Housing Programs Manual for tenants' rights is 1,000 pages long. I just checked while Susana was talking. That includes all the CFRs and cases that apply to subsidized housing. So we're not going to talk about all of that, but just going to let you know that there are some additional things that you need to be aware of if you come across a case that involves any kind of federal subsidy. So the first thing that we're going to talk about, because this is the most common thing that we see in West Virginia, is the Section 8 voucher or the Housing Choice Voucher. You'll probably hear it called Section 8. And it's important to know if a Section 8 voucher applies, because there is a whole other party to this scenario here, and there are 2 additional contracts that need to be considered. So as you can see on the graphic on your screen, if a Section 8 voucher exists, the tenant has a lease with the landlord. The landlord has a housing payment assistance contract with the Public Housing Authority, which allows the Public Housing Authority to pay the landlord directly on behalf of the tenant. And the tenant has a contract with the Public Housing Authority called the Section 8 voucher, which includes a number of additional tenant and family responsibilities that the tenant has to be responsible for. So in an ideal world, all 3 of these contracts are going to be completely followed. No one's going to have any problems. But there are some additional things and requirements that are set forth by the federal code that impact these. So under a Section 8 voucher program, the housing authority pays the landlord this portion of the tenant's rent that is set out by federal statute based on the tenant's housing situation. The tenant pays the rest of that to the landlord directly. And again, the amounts are determined based on the tenant's household income and size. Premises must pass an inspection. This is a separate inspection. It is a much higher standard than our warranty of habitability. The housing quality standards are set by the federal statutes and by the housing authority, who has their own inspector who's going to come out and make sure that this property meets those standards. The housing authority has to approve a property before a voucher can be put in place. Side payments are illegal. Landlords cannot request any additional money or accept any additional money from a tenant under a Section 8 voucher. They're going to be held liable under contract and federal law, and they will be prosecuted. There are lots of forms of federally subsidized housing. You know, we're talking public housing, project-based Section 8 housing, low-income housing tax credit properties, rural development 515 properties, shelter plus care, et cetera. Those all have their own different regulations. They all have their own manuals and books and sections in the Code of Federal Regulations. So just what we want you to be aware of is if you're dealing with subsidized housing, there is a whole other section of law that you need to be aware of. But because Section 8 is the most common thing you're going to see, we'll just give you a brief overview. So in a Section 8 voucher contract, the initial term of the lease must be a year. There is no exception set out by federal law. It has to be a year. And during that first year, eviction is only prevented for 4 reasons: for serious or repeated violations of the lease, for violations of federal, state, or local law that impose obligations on the tenant in connection with the occupancy or use of the premises, for criminal activity or alcohol, and for other good cause. And what all of these examples of all of these things mean are set out in the Code of Federal Regulations and in federal case law, which is why we just have to be aware that there are more things in play here. The tenant is entitled to notice of the eviction, and those allegations must be stated with sufficient particularity to allow the preparation of a defense. That's a big thing, that tenants are entitled to specifically know the exact reasons why they're being evicted. The landlord also has to provide notice of that eviction to the housing authority, because they're another party to this contract. And an owner can own, or a landlord can only evict through court action. Self-help is specifically prohibited under the HAP contract, the Housing Assistance Payment Contract. So landlords, when they accept Section 8 vouchers, they generally are getting much more reliable rent payments from their clients, but that does come with additional obligations that they have to agree to take on and enforce. So to go back to the question, we'll switch gears here. This is kind of the final thing we're going to talk about. Factory built home rental communities, mobile home communities. What happens if folks are renting a lot or land? So mobile home parks are specifically regulated in the West Virginia Code. They're defined as a piece of land that has 2 or more factory built homes on it. So if a landlord has a piece of property, lets 2 people pull in their trailers there, they are now a mobile home park, and they are subject to West Virginia Code 3715 and all of the statutes that follow that. In a mobile home park, the tenant is the owner of their mobile home, but they're renting the lot where it's situated. It's a different scenario if a tenant is renting a trailer. That would also be a landlord-tenant situation, but this would be a mobile home park situation, and the tenant's going to pay lot rent to the owner. There are specific requirements for these tenancies. The first is that everything has to be in writing. That is a requirement in the code. Everything has to be written down, and the written lease must also contain specific language set forth in the code section. Sometimes landlords may not be aware what they're getting into when they agree to let folks, rent lots. So that it's important for landlords to be aware that there are specific requirements. The maximum or the minimum length of tenancy is also set forth in the statute for mobile home parks. Single wides is 12 months and a double wide is 5 years. So a landlord cannot really evict prior to that unless there's some good cause. Tenants cannot be restricted in any choice of vendors in their mobile home or any other goods or services, except for reasonable requirements about the size, style, or quality, that kind of thing. And that's 3715.5. Evictions are also specifically set out in the statute regarding factory built rental communities or mobile home parks. Generally, landlords have to give 3 months written notice prior to a termination date, which is a lot longer than a standard if we're talking about a regular landlord-tenant situation. That notice must include specific facts to permit determination of the date, place, witnesses, and circumstances concerning the reason for termination. Landlords can also not restrict the sale of a tenant's home if that termination is not for good cause. Longer notice is required if we're looking at larger mobile home parks. I think this comes from a situation in Morgantown several years ago. 25 tenants in a, affected in an 18-month period, it causes a problem under the statute. The wrongful occupation of a factory-built home site is a specific action, and it applies whether the home is just a single site or in a community. So that's a specific thing that a landlord or lot owner would need to file. And the relief is distinguished from ordering the tenant to vacate and ordering the tenant to remove the factory-built home. So those are two different things that can be awarded under that action. If
not only can they both be awarded, the dates will often be different, right? So you can tell a tenant that they have to leave, but the reality is that moving a mobile home is expensive and takes time. So the magistrate can say to the tenant, you have to vacate by X date, but you have 2 additional months to remove the trailer, because again, they own their mobile home, so they have a right to obviously take the opportunity to move it.
Right. And there are specific remedies set out in 55(3)(b) about remedies for what happens if a tenant doesn't remove a mobile home, or sometimes mobile homes can't be removed, depending on the structural integrity. So what happens then? Landlords can dispense of the home if the tenant informs them in writing that they're abandoning it. They can also remove and store the home for 30 days. Also note that remove and store leads to selling, not disposing, different things, very, like Susana said, highly technical stuff here. Landlords may leave the home in place and then sell the property after 30 days if the tenant has not paid for storage. And the proceeds of a sale of a mobile home under this section have to be distributed pursuant to UCC Article 9. So that's the big kind of takeaway here. If there is personal property or personality left in the home, generally landlords are going to need to follow the provisions that Susana talked about regarding what to do with personal property that is abandoned under 37. And I think that is it. Susana, do we have anything else?
I think we flew through our materials in exactly 50 minutes. I'm feeling pretty good about that. I'm going to just very quickly just plug that hopefully we gave you all just enough to feel a little bit comfortable to, do an answer on free legal answers. But if you feel, empowered to consider taking on some volunteer work, particularly knowing that, we have this MRAP available, that, the eviction moratorium is ending at the end of the month. I added in here, it's not in the materials you receive, but if you are interested in volunteering, there's a direct email that you can put into our pro bono coordinator and express interest in any sort of work that you might be interested in doing with legal aid. And the last thing that I will say is that if you do volunteer to do work with legal aid, we don't have a conflict, right? We just need more help. And so we are always happy to answer questions, to partner, and to be available. So if it's your first round, we're happy to, to chat. I've done that lots of times with folks who've taken on these cases, and we're available as a resource for you all. And quite frankly, I think these are really great, they're pretty quick. I mean, they're, as we've identified, the court process moves very quickly in these. It's a good way to make a big difference in someone's life, but not have a case that's going to take you 3 years. And but again, has a big impact on people's lives and a family's life. So if you are interested in taking these on, you don't have to do so based solely on the 50 minutes that we have now blessed upon you. And Anita, I think we send it back to you. Is that right?
Yes, I'd like to take about 30 seconds to first of all thank all 5 of our speakers. Very impressive presentation. As I mentioned earlier, you will receive an email giving you 3 hours of credit. Please be sure you accept that or adjust it as needed. It should go out today, but don't worry about it until Monday. Check your trash and then call us if you didn't get it. The program, all the speakers agreed to allow us to put this online It depends on once we get confirmation that they're agreeable. I think they did such a great job. They're all going to say yes, but we have to get the confirmation from them. And then Mike Mellis will put it online. On the chat, Kate White of Legal Aid presented some information. I asked her to share that with me via email for those of you who do not do the chat room. And Kate has provided that. I've asked Mike to send that out, so look for that also. And then the last thing that I want to mention is I try to hit up people I know. If anybody wants to volunteer, I am not shy. I will hit you up if you say, yeah, I'd like to help. So our next presentation, I do one of these or coordinate one of these every other month. Our next presentation is going to be on September 22nd. It will be from 9 a.m. until noon. It will be a presentation on mental health issues, and among other things that it will include is information regarding requests for and introduction of documents dealing with psychological and or other mental health issues. The presenters will be Dr. David Clayman and Dr. Stephen Cody. We will be putting information in the bar blast in the next few weeks about the September 22 presentation, but it's going to address civil and criminal. It's going to address from both sides of the V. So if you do anything with mental health information or records, please put that on your calendar now. Again, it will be September 22, and it will run from 9 till noon. Thanks to everyone who was involved in this. And I always thank him separately, but I want to thank him right now in front of all of you on this. Mike Mellis makes this all possible. If it were not for Mike's IT help, I would be sorely lost with that. And so I want to thank Mike for all the work that he does for us also. Have a good afternoon, and hopefully we'll see all of you guys again online or at the Bar Center on September 22.